In view of the aforesaid facts and circumstances, we are of the opinion that the impugned order dated so-and-so, passed by so-and-so, does not call for any interference. Writ petition is dismissed.
Ma'am, look, for my personal problem, Lord, item number 5, 7, 13, and 19. Maybe taken next witness then, Lord.
Why? What is the difficulty?
My personal thinking. It's like some
Okay. 5, 7,
13, 19.
5, 7, 13, and
19, online.
when do you want?
Next witness the Lord.
Okay. Sri A. Rashid, learned counsel for the petitioner, has submitted that, has paid for an accommodation by submitting that he is not well. Full stop. In view of the aforesaid submission, para kori, huh? In view of the aforesaid submission, matter is adjourned to be listed after a week. Separate orders. 5, 7, 13, and 19.
I beg to mention listing order column, my lord. The
Order why?
My lord, the petitioner in custody, my lord, more than 5 men, and he was suffering, my lord, various problem and especially eye problem. He is unable to move, my lord. So,
have you filed any IA?
yes, my lord, that
When-
IA, my lord.
When have you filed the IA?
Yesterday, my lord.
Okay. When do you want?
Friday, my lord.
Friday it cannot be possible. Monday.
Hello.
Has it been numbered? Get it numbered. And we'll have it for Monday.
May please, the lordship. But should I beg to mention, my lord, item 8? My lord, I am taking some accommodation, my lord, next week.
Why? What is the difficulty today?
But due to my illness, my lord, I could.
Illness. You look fit and fine.
Plus,
You have tried to demonstrate your illness by coughing.
no, no. No, my lord, since last 2 days.
Evidence. You want to cross-examine? If you want, you are allowed. Okay, same order. MR Khandekar. I got this in 1 week. Yes.
Please, your lordship, my lord. My lord, I have a prayer in item 33, my lord.
Yes.
My lord, this is a habeas corpus matter, my lord, and the bail is still under consideration, my lord. Lordship will be pleased to take it up along with my another matter, my lord, item 23, my lord, just after 23. Because, my lord, in the second half, I have a medical emergency. One of my relatives is hospitalized, my lord.
You cannot assure. The other matters are FT matters.
Yes,
Those
my
are
lord.
also important.
Along with 23, my lord. It is
23, no,
one matter of
23, 27, you have to wait. We may take it as the first admission dispute. That's a different matter.
My lord, my lord.
This will require another consideration.
My lord. My lord.
We'll see. Otherwise, we'll have it on Friday or whichever date.
My
If you have a
lord. We'll be
different.
waiting till.
Okay.
Sure.
Wait,
Yes.
please, your lordship. Lordship, I beg to mention item 29, 34, 35, 36, and 37. Here the arguing counsel is out of station and we have circulated adjournment petition yesterday.
Okay. On a request made on behalf of Ms. D. Ghosh, learned counsel for the petitioner, matter is adjourned by 2 weeks. 2 weeks. 2 weeks. Separate order, huh? In 29, 34,
35,
35,
36, and
36.
37.
37. Separate orders.
Deeply.
Please, your lordship. I beg to mention item number 20 and 26, your lordship.
Yes.
So kindly these matters come after 1 week, your lordship.
On behalf of whom?
I, Hussein, your lordship.
What is your name?
M. Medhi.
You are also there.
Yes, your lordship.
26, 20 and 26.
20 and 26.
On a request made on behalf of the petitioner, matter is adjourned to be listed after a week.
Oh, bless you.
20 and 26.
20 and 26.
Yeah, please, your lordship. Lordship, in item number 39, an affidavit in reply was filed. That may be
30,
called
39.
39. Manjil Hussain versus. An affidavit in reply was filed yesterday. That may be called from Malad.
Okay.
I'm
Get
so
it.
obliged.
Please, your lordship. Lordship, I'm praying for listing of a writ petition for admission, my lord, on Friday.
Writ petition of what? What nature?
The matter, my lord.
FT, why out of turn admission?
My lord, it was fixed for admission.
Hmm.
And due to paucity of time for the fifth occasion, it was not heard, my lord.
It will be difficult. Monday.
My lord.
Except motion. Petitioner order to mention in one place. যদি urgency হয় যদি admission order করা মানে এখন mention মেমো যায় কিন্তু একজন দেয় মোশন দিন কোনো প্রবলেম নেই না থাকলেও কিন্তু pending matter unless you make out a case of urgency suppose কোনো compensation পাওয়া নাই land acquisition that's what you need to do the pension may ensure that cover growing price like you want to buy then the pension before the registry will be fine. No, no, unnecessary, basically, both with the BOG or a totally requisite. BOG, or agenda. Yes, Mr.
My
Mohan.
lord, in compliance to the order of this Honorable Court, my lord petitioner and one his uncle, my lord, uncle, went to the Matia, my lord, holding center.
Hmm.
But the in charge, my lord, the holding center, Matia, he told my lord, in such name, there is no any person, my lord. But that is the petitioner, my lord, petitioner's father, my lord, he was not,
He's not there.
yes, my lord.
Then what do you do?
My lord, habeas corpus petition, my lord.
No, what do you do then? Yes, yes. Okay. Oh, no. Yes,
Yeah, Lordship may allow to take instruction, Lordship. That way, already I have placed earlier, I have placed one instruction, Lordship. Regarding.
no, the instructions which you have placed before this court on 3rd of October,
Yes,
it says that he was declared as a foreigner
Yeah.
and was kept at the holding center at Matia.
Okay.
Now they have gone there and they did not find him there.
Yes, Lordship.
How is it possible? When did you go?
my lord, on 7/11.
7/11.
Yes, my lord.
Sri R.S. Chauhan, learned counsel for the petitioner, has submitted that the relatives of the proceedee who has been declared a foreigner had gone to meet him at the holding center Matia and was informed that there is no such person. There is no person by such name.
Yes.
Full stop. Sri Sharma, the learned standing counsel, Home Department, is directed to obtain specific instructions
Yes, Lord.
on the same. Full stop. Such instructions are required in view of the earlier written instructions dated 3/10/2025, which was placed on record, as per which, the proceedee was handed over to the holding center Matia on 25/5/2025. List this case on when? Wednesday next.
Yes.
Wednesday next. Give the date, please.
Obliged.
Next witness day. 19.
Mr. Ahmed,
My lord, petitioner, he was at detention camp, my lord.
Hmm.
So record may be called for a matter of exam.
let us see the basic facts.
Basic facts, my lord. The petitioner has appeared and thereafter remained absent.
Did you file a written statement?
My lord?
You had filed a written statement.
No, sir, not. Then
And you appeared where? Which year? 2014.
Yes, my lord.
After
yes.
10 years, you have
Sir.
woken up.
Yes, my lord. Now
And the opinion is of 16.
yes, he was arrested and now he is detention camp. When is 2016, my lord?
When are you arrested? Heard Sri J. Ahmed, learned counsel for the petitioner, who by means of this application
17/5/2025.
has to challenge an order, an opinion dated 13/6/2016, passed by the learned foreigners tribunal Bongaigaon number 2, Obhayapuri, in FT case number so and so. Full stop. It is the case of the petitioner that he had appeared before the tribunal on 4/4/2014 and thereafter had remained absent, and the opinion was rendered on 13/6/2016. Full stop. It is contended that the petitioner has been arrested recently on
17/5/2025
17/5/2025 para
and the detention camp at Matia.
and has been kept in the detention camp at Matia, Gwalpara. Full stop. Let notice be issued. Returnable by 6 weeks. Union of India. Union of India. Yesterday somebody was there, Adhikari. Can you record his name? Is he there in the court?
Yes, Lordship.
MR Adhikari or whoever, or RKD Chaudhary, whoever. SK Methi. Who's there in the court? We want somebody to be who's there in the court. Have you met Adhikari today? Mr. Sharma?
No.
Adhikari is there or not? Huh? SK Methi, yes, sir. S. Talukdar. Have you met whom have you met? Any CGC? We cannot record somebody's name who's not in the court.
R. Chaudhary is there, Ranjit Chaudhary.
RKD Chaudhary. Sri RKD Chaudhary, Deputy SGI for 1. Then Sharma for 2.
Yes.
2 and 2, 4. 2, 4. 2 and 4.
Yes, sir.
3 Election Commission of India.
Yes, Lordship.
It will be appearing.
2, 4 and 6, Lordship.
You are what Kalita and Kalita?
2, 4, 6 and 7, Lordship.
Huh?
I'm appearing.
2, 4,
6 and
6
7.
and 7 also will take. Okay.
Mm.
And Kalita for Election Commission of India 3.
Yes, Lordship.
Anybody else?
I'm this one now 5.
5 P. Sharma addition Senegal, you know? Extra
5 and
copy.
7 also.
Hmm?
5
No,
and
no.
7 also.
7 is
7 OC.
Oh, 6.
7 is
I'm appearing.
7. Okay. Let the records of the tribunal be requisitioned. Okay.
Maintainability maybe kept open.
The issue of maintainability on the ground of laches and negligence is however kept open.
Alada, he may not be deported.
Better not to make any prayers.
No, I make.
Better not to make any prayers.
He may be deported. That is right.
Let him be deported. You deserve to be deported. 16 and you come after how many years? 9 years.
My lord.
You took the chance.
My lord.
We'll consider on the next day.
That will be observed.
The prayer for interim relief would be considered after receipt of the records.
Hello, sir.
May I please, my lord?
Yes.
My lord, impugn order on page 85, my lord. Whereby petitioner declared foreigner of the post 1971, my lord. No, my lord, during trial, my lord, petitioners exhibited the voter list in
Okay.
respect of his
Your
grandfather.
J.A. Ahmed. Your J.A. Ahmed.
K.M. Hassan.
K.M. Hassan. Heard Sri K.M. Hassan, learned counsel for the petitioner who has put to challenge an order dated 18/8/2025 passed by the learned foreigners tribunal number 3, Kamrup M, in FT case number so and so, whereby the petitioner has been declared a foreigner under the Foreigners Act 1946. Full stop. Let notice be issued. Returnable by 6 weeks. 3. 1 RKD Chaudhary, Election Commission of India by S. Kotoki, Miss S. Kotoki, Standing Counsel.
3, 4, 5 and 7, Lordship.
3, 5,
3, 4, 5
3,
and 7.
4, 5 and 7 by Mr. Sharma, Standing Counsel, and
Number 6.
6 by P. Sharma. Huh? Para, let the records of the learned tribunal be called for. Para 3. After the learned counsel prays for an interim order. Considering the above, it is directed that till the returnable date, no action for deportation of the petitioner be taken.
May not be arrest, my lord.
You are not taken into custody.
No, my lord.
Till the next, has read for interim order and has submitted that till date, he has not been arrested. And the petitioner has not been arrested. Full stop. Considering the above, it is directed that till that will give the same order, huh? I reached this, we'll pass some conditions.
Ma'am.
Okay, you'll have to appear.
Lordship, my lord. Deeply obliged.
Identification including Iris and. We're granting bail, Mr.
Yes,
Because he's not, if he's not arrested, if he's arrested, then no deportation.
My lord. Lordship.
May it please, Lordship. In this case, Lordship,
If not arrested, please, sale of order, no? Yes,
Contested case, I'm in outside Lordship, in implement page 84.
no, not yet taken into custody.
Lordship, I have, sorry.
You are JM Suleiman?
Yes, Lordship.
JM Suleiman, কে হবো, হ্যাঁ? আগর কিন্তু সব ঠিক করে দেবো এবার। Order included 25/7. But your opinion is of which date?
So, Lordship. Opinion in page number
Which
84.
date?
Date.
Date.
Date. Lordship, 84, like 7/8/25.
7/8?
25. 2025.
Where have you stated?
Page number 84.
In the synopsis, you have not given the most important date. In the synopsis, you have not given the most important date. Why is this kind of negligence? Why is the synopsis given, presented before us? Which date, 20th?
Civil Lordship.
25/7, no, 20, is it 7/8/2025?
Yeah.
7/8/2025 passed in so, huh? বাকি খিনি সব একই হবো, issue the notice. One, RKD Chaudhary. Oh, Mr. Adhikari will be taking notice. Mr. Adhikari, MR Adhikari, CDC 1. Then G Sharma for 2,
5 and 6.
2, 5 and 6. District Commissioner, P Sharma, 3. Then Madam, oh yes, and Kolita, you're standing counsel
No, lordship. On behalf of AIRL, lordship.
on behalf of I go to the list, and Kolita, on behalf of AIRL, huh, standing counsel for 4.
Yes.
4, okay. Then last part, raise for an interim order and has submitted that till date the petitioner has not been arrested. Then same order, huh? Okay. Only if you are not arrested. Call for the records, করিস না আগতে? আগর পরে এটুকু করিব call for the records, সব call for the মু draft মারি দিব এটা সাইড। এমআর ঠিক করে না লাগে? না লাগে, থাকো। এটুকু করা। না স্যার। Item number? Mr. Rahman. None appears for the petitioner on call, whereas the learned counsel for the respondents are present. Para, in the interest of justice, list after 2 weeks. No, list after a week, don't say 2 weeks. They'll share it here politically. Item 9.
May it please, Your Lordship.
Mr. Laskar,
This is a contested case, Your Lordship, declared foreigner post 1871.
arrested already,
Not yet.
not yet arrested. Um, and same order, huh? M.H. Laskar. Twenty-four, 2024. From 24, you're not yet arrested.
Not in this.
24, 12.
12, no.
You're not arrested, same order. Okay. Kune labo, no. Yes, we'll accept notice.
No.
One adhikari, 2, 3,
Two.
and 5. G. Sharma and Election Commission. Okay, Miss S. Kotoki. Extra copies, call for the records, and same order. Interim, praise for interim order. He is submitted, not yet arrested. Upside to Kuriju.
Obliged.
May please, madam.
Yes.
In your opinion, 1 2025 page 39 actually. Is not as the person.
Yes, what is your name?
P.
Bora. P. Bora, huh? Order to hold 1/8/2025. Passed by the Puntu Foreigners Tribunal Salabite, huh? Foreigners Tribunal, Nagaon. Is it Nagaon?
No.
Or number 3? Foreigners Tribunal number 3, Nagaon, huh? Baki is Sabaki. Please call for the notice, call for the records of this incident. And who will accept notice?
One,
One,
two,
two.
sorry.
State of Assam, 1, G. Sharma for 1,
1, 4, and 6. Not
1, 4, and
Six.
6. Then MR Adhikari 2,
Two.
P. Sharma for 3. And 5 S. Kotoki, sending council. No? Extra copies. You are outside or behind the bars?
Outside, actually.
Outside,
Yes, Lordship.
same order, huh? Current statement to record Krupa says that he is not yet arrested. Very.
I love it.
Please,
Yes.
the FT order is at page 39. I am outside the bar. I'm outside. The order is of date 23/2020.
20,
20.
order which it?
23/2020, page 39.
23, 2020.
Yes, sir. As I have reasonable minutes, I have explained the delay at page 27.
Your explanation will have to consider the appropriate stage, not a case for bail. You come to the court after 6 years.
I have explained it all, my lords, in my pleadings.
Sorry. We'll issue notice, make the maintainability point also open. Heard. What is your name?
DK Agarwala.
Heard Sri D.K. Agarwal, learned counsel for the petitioner who has put to challenge an opinion dated 23/2020 passed by the learned Foreigners Tribunal 4, Nagaon, Juria, insurance. Let notice be issued returnable by 6 weeks. Adhikari for 1, MR Adhikari 1, Election Commission, and Kalita on behalf of AI Ali, Standing Council, the Election Commission of India.
For 3, 5 and 6.
3, 5 and 6, G Sharma. And 4 is P Sharma, State Council. The prayer for interim relief would be considered after receipt of the records.
No deportation till then.
Maintainability may be kept open lot.
Yes, however, it is directed that till the next date fixed, the petitioner shall not be deported. Full stop para. The question of maintainability of this writ petition on the ground of laches as raised by the learned state council is however kept open.
Much obliged.
May I please, my lord? Petitioner declared foreigner in post history. My lord, opinion page number 37, my lord, dated 8/1/2019. And another opinion, my lord, parallel in the same to Dhemaji district, 31, page number 41. It's res judicata, doctrine of res judicata. 2022.
But which is the opinion you are challenging?
I'm challenging my lord,
8/1/19.
I'm challenging my lord, first one, 2019, my lord.
19 you have come now, why?
My love, very poor, my love, financial hardship.
Huh?
Very poor person on the financial hardship is not here.
Financial hardships. What is your name?
My lord, from
Your name?
Mofid Ali, Elias.
No, your
Mofid
name,
Ali Sheikh.
council, your name.
My name, T. Muhammad.
Team Hartford, T. Mohammed, the net counsel for the petitioner who has put to challenge an opinion dated 8/1/2019, passed in FP case number FP case number so and so by the learned foreigners tribunal first Dhemaji. Post up, para. That notice be issued returnable by 6 weeks. Union of India, MR Adhikari for 1, G Sharma,
2, 4 and 6.
Standing Council 2,
4
4
and 6.
and 6. 3, P Sharma, additional sitting advocate 3, and S Kotoki,
5.
Standing Council, Election Commission India for 5. Call for the records, extra copies to लिखी भाई supporter. 3, Mohammed, the learned council pays for an interim order, para. Till the next returnable date, it is directed that no steps for deportation of the petitioner be taken, para. The issue of maintainability, which however, which has been raised by the learned state council on the ground of laches and negligence, is however kept open. You give extra copies, furnish extra copies, okay?
May I please? But this is an expertise order, your lordship, against me, my lord. But I could not serve notice, your lordship. So service report is also there, and in the expertise order, it is reflected the service report, your lordship. Kindly come on page number 40, your lordship.
Let us see the impugned order,
My lord, impugned order, page number 39.
3/9.
39, yes, lordship. Right. And page number 40, it has been reflected, your lordship. Second para. Accordingly, after. May I read, your lordship?
Yes, please.
Accordingly, after registration of this case, notice was issued to the OP to appear and to file written statement and to produce evidence in support of his citizenship. After service, notice returned with service report. On perusal of the service report, it is found that in pursuant to the notice, the process server went to the address mentioned in the notice, and after inquiring the local place, people come to know that the OP had left the aforesaid place and went to some other place without intimation to the investigation agency.
Due to the aforesaid circumstances, the process server, after due in diligent search, could not locate or find out the last staying resident of OP. And as an alternative, FX placed a copy of the notice on
When
the.
did you come to know about this order?
Hello,
How did you come to know about this order?
well, I come to know, Your Lordship, it is expired order passed on 2018-2024. I come to know.
How did you come? How did you come to know?
July or August, Your Lordship.
How?
Oh, police was arrested me, Your Lordship. Thereafter, I was released, and I am now.
Police arrested you from where?
From my location, Your Lordship,
Which location?
Romari Pathar. I am still now, I have been residing at the aforesaid resident of Romari Pathar, Your Lordship. Sorry, Romari Gao. Romari Gao and Pathar is the address place. My birthplace is Romari Gao. Still now, I have been residing at Romari Gao, Your Lordship. And each and everywhere, my lord.
But the Sarkari Gampura has also given a certificate. And notice was deemed to be served under the provisions of the Foreigners Tribunal's Order 1964. Mr. Sharma, isn't it?
But my lord,
There is a finding.
Yes, Lordship, as per 35F.
35F.
Yes, Lordship, but I think, Lordship, my humble submission is that Lordship 35F is not complied with in this order. So Lordship may remand back the matter.
Yes,
And within 60 days, Lordship may
Why
allow
is
to
it not,
dispose of
why
it
is it not complied with?
because Lordship 35F.
Gampura, the dispute, FX police. Notice has been given to certificate of this. The process server along with the service report appended the certificate.
my lord.
Certificate.
At page number 33, the Sarkari government has been issued.
The proceeding has changed the if the proceeding has changed the place of residence or place of work without intimation to the investigating agency, the process server shall affix a copy of the notice on the outer door of this some other conspicuous part of the house in which the proceeding ordinarily resides or does resided. He
Referring to which
order
1964 orders.
in 1964 orders, Lordship.
Okay.
So here notice was affixed in the Gaubura's notice board,
Correct,
Lordship.
correct.
That is why I am saying, Lordship.
It should be affixed where?
As per order, Lordship, it was,
Where it should be affixed.
Lordship, in conspicuous place or where the proceeding last resided, Lordship.
150.
35F. In this book, 160, Lordship, page numbers.
Okay. Then we'll fix a date for filing the written statement.
Lordship.
Okay. And from that date onwards, the learned tribunal will take charge and complete the proceeding.
Within 60
expeditiously.
days, as per 314. In 60 days.
Heard. What is your name?
As Islam, my lord.
Heard Sri S. Islam Learned Council for the petitioner. Also heard Sri G. Sharma Learned Standing Council, Home and NRC,
Yes.
Sri M.R. Adhikari Learned CGC, Sri G. Sharma Learned Addition Senegal Advocate, and Ms. S. Kotoki, Standing Council, Election Commission of India. Full stop. Considering the subject matter involved and as agreed to by the learned counsel for the parties, the instant writ petition is taken up for disposal at the motion stage itself. Full stop. The petition, the instant petition under Article 226 of the Constitution of India has been filed challenging an opinion dated 28/8/2024 passed by the Learned Foreigners Tribunal number 7, Borpeta, in case number so and so. By the aforesaid opinion, the petitioner has been declared an illegal migrant post 1971 stream. Full stop. Para? Through Islam, the learned counsel for the petitioner has primarily based the present challenge on the fact that on the contention that the impugned order has been passed ex parte against the petitioner without giving any reasonable opportunity. Full stop. By drawing the attention of this court to the impugned opinion, comma, the learned counsel has submitted that though there is an observation that notice was deemed to be served as per the provisions of Order 3 within bracket 5 within bracket F of the Foreigners within bracket Tribunals Order 1964, comma, there was no fulfillment of the requirement of the aforesaid provision of law. He has submitted that as per the impugned opinion itself, comma, the copy of the notice was affixed in the office of the Gaon Bura, which is not one of the prescription of the law relating to service of notice. Full stop. He has submitted that due to the lack of information regarding the proceeding, the petitioner could not contest the same, resulting in the impugned opinion. Full stop. Para. 3. G. Sharma, the learned standing counsel, has fairly submitted that though certain observations have been made in the impugned opinion regarding service of notice upon the petitioner proceeding, comma, the same does not appear to be in strict conformity of the requirement of Order 3(5)(f) of the Orders of 1964. Full stop. He submits that in case the proceeding changes the place of residence or place of work, comma, notice has to be affixed on the outer door or some other conspicuous part of the house where the proceedee ordinarily resides.
Oh,
Full stop.
no.
Para. The learned counsel for the other respondents have also endorsed the said position of law. Para. Order. What do you call it? You call this orders or clause?
Order.
Order 3.
Order 3.
Order
Order
3,
3,
5(f) of the Foreigners Tribunals Order 1964 reads as follows. Eto quote kori diba. The said order is in connection with service of notice to a proceedee in a situation where the proceedee changes his place of residence or place of work without intimation. Full stop. The requirement is to affix a copy of such notice on the outer door or some other conspicuous part of the house where the proceedee ordinarily or last resided. Full stop. In the instant case, comma, it is not in dispute that the notice was affixed on the office of the Gaon Bura, which does not appear to be in conformity of the aforesaid provision of law. Full stop. In view of the above, comma, we are of the opinion that the notice of the proceeding was not served on the petitioner in accordance with law. Full stop. Situated thus, comma, we have no other option but to interfere with the impugned opinion dated so and so, huh? We make it clear that such interference is not on the merits, inter se merits of the parties and only on the aspect of the service of notice. Full stop. We also direct the petitioner to appear before, since the petitioner is presently having the knowledge of the proceeding, comma, we direct the petitioner to appear before the learned so-and-so tribunal on, give a date, please. Today is 12th. On 26th, 2 weeks. Or 24th,
26 Your Lordship.
on 25th, on 25th. 25th. With he or her,
He,
with his written statement, which would be accepted by the learned tribunal, whereafter the tribunal would take charge of the proceeding and conclude the same expeditiously in accordance with law and with the provisions of
314. 3 in bracket 14.
314.
The foreigners tribunal shall dispose of the case within a period of 60 days of the receipt of the reference from the competent authority.
Yes. 314. Full stop. The writ petition accordingly stands allowed in the manner indicated above. The petitioner is at liberty to furnish a certified copy of this order along with the written statement.
Please, Your Lordships. Lordships,
Item number
15 Lordship.
15. Yes, what is this?
The opinion is of year 2019 Lordship. There is delay, Lordship, I admit. So under some.
Even if you do not admit,
Lordship,
even if you do not admit there is a delay.
delay is
You say you admit there is a delay.
a delay caused in filing this writ petition, Lordship. And there is.
Even if you do not admit there is a delay, it's a matter of fact.
Yes, Lord.
You cannot help.
Yes, Lordship. And the impugn opinion is at page 86, Lordship.
Okay.
Page 86.
You're Zaid Hussain.
Yes, Lordship.
Hard Sri Zaid Hussain, learned counsel for the petitioner who has put to challenge an order dated 15/5/2019 passed by the Foreigners Tribunal 4th Dhubri in FT case number so and so, whereby the petitioner has been declared a foreigner post 25/3/1971. Para, let notice be issued, returnable by 6 weeks. Union of India, MR Adhikari, 1. Then home to
2, 4 and 6.
B.
Lordship.
Sharma,
2,
Setting
4
Council
and
home for 2,
4 and 6.
4 and 6. Election Commission of India, Madam S. Kotoki for 3. And P. Sharma for 5. 5 extra copies. Call for the records. 3. Hussain, the learned counsel prays for an interim order. On the other hand, the learned counsel for the respondents have raised an issue of maintainability
Yes.
on the ground of delay and latches. Full stop. Para. Considering the above, while it is directed that till the next date fixed, the petitioner is not to be deported, the issue of maintainability on the ground of delay and latches is, however, kept open.
16 Lordship, an ex parte order was passed, Lordship, against the petitioner on 8/10/2021, Lordship. And herein he filed a written statement, Lordship, with the relevant documents, but unfortunately, due to the eviction in Dholpur, Lordship, he had
Who will
to
issue notice here?
shift,
Hard
Lordship.
Sri J. Hussain, Zaid Hussain, learned
Yes, Lord.
counsel for the petitioner who has put to challenge an order dated 8/10/2021 passed by the Learned Foreigners Tribunal fourth in case number so and so, huh? By which
Yes.
the petitioner has been declared a foreigner post 21/3,
Yes, Lord.
post 1971. Full stop.
Is it
It is submitted that the aforesaid order is an ex parte one. Full stop, para. Let notice be issued, returnable by 6 weeks. Union of India MR Adhikari, 1 MR Adhikari, huh? Then G Sharma for 2, 4, and 6.
2, 4, and
Correct?
6. Yes, Lord Chief.
2, 4, and 6. S Kotoki, Standing Council, Election Commission of India 3, and District Commissioner 5 is by P. Sharma. Okay. Extra copies. Call for the records. Okay. The Learned Council for the respondents have, however, pointed out that the projection made that the order has been passed ex parte is not factually correct, as the petitioner had appeared and thereafter had neglected to contest the case. Full stop. 3. So Hussain, the Learned Council prays for an interim order, para, considering the facts and circumstances. It is directed that till the next date fixed, no steps for deportation of the petitioner be taken.
Sustainability also may.
The issue of maintainability is, however, kept open. Mr. Das?
Yeah, please. No, it's a contested proceeding, my lord. Lordship will find the impugned opinion at page 54, my lord. Annexa K.
Why are you so late in coming to the court?
Yes, my lord, admittedly, there is a delay, my lord.
Hmm?
Yes,
Or-
my lord.
3. You thus Learned Counsel for the petitioner who has put to challenge an opinion dated, what the order is opinion, opinion dated 29/4/2024, passed by the Learned Foreigners Tribunal 4th, Walpara in so and so case, huh? Case number 2. Case number. Whereby the petitioner has been declared a foreigner post 25/3/1971. Full stop. Let notice be issued, returnable by 6 weeks. Union of India. Adhikari, MR Adhikari 1. Ms. D. Sharma for
2, 4, and 6.
2, 4, and 6. And Kolita on behalf of A.I. Ali, Standing Council, Election Commission of India for 3. And for P. Sharma for 5. Extra copies, huh? Call for the records. What to call for the record, please, huh? 3. Das Learned Council prays for an interim order, which, however, is registered by the Learned Council for the respondents, para, considering the facts and circumstances, and also the aspect of delay in approaching the court, it is directed, court, this court directs, this court is of the opinion that the petitioner would be entitled to certain limited protection, full stop. It is accordingly directed that till the next date fixed, the petitioner shall not be deported, full stop. The prayer for grant of bail would be considered on receipt of records.
May I please? But if the petitioner has been declared as foreigner post 71 by impugn order dated 3rd of July 24. Impugn order is at page 63, Annexure D. It is passed by Foreigners Tribunal, Bongaigaon number 2.
Your Pathak.
Yes.
Heard 3 M. Pathak, Learned Counsel for the petitioner who has put to challenge an opinion dated 3/7/2024 passed by the learned foreigners tribunal Bongaigaon 2 in so case number, huh? Whereby the petitioner has been declared a foreigner post 25/3/1971. Para. Let notice be issued, returnable by 6 weeks. Who will accept notice?
We should notice for one.
I'm for 2, 4 and 6.
1 MR Adhikari, CGC, G Sharma for 2,
4 and
4
6.
and 6. N Kolita on behalf of AI Ali, Standing Council, Election Commission of India 3, and District 5 is P Sharma. Huh? Bisarkini একটি পড়ে দিবা, হ্যাঁ? এইমাত্র দিনটো ছিল, interim order to bail will be considered on the next date, not to be reported.
Meanwhile, she may be protected from arrest.
That
not
you
to
have
be
come
reported.
after 1 year. We'll consider on that after it's state of records, till then no deportation.
Not to report this, eh?
May I please, Your Lordship? Lordship, the writ petition has been filed by the wife of Hussein Ali, who has been illegally detained by the Roha police station on the midnight of 28 May of 2025, Lordship. Lordship may consider there is no foreign tribunal case against him, nor he was ever marked as a devoter, Lordship. He is a Indian by birth, Lordship, and it has been illegally detained by the police, Lordship, and he has
There is no proceeding against.
no.
Yes, what is it?
Yes, Lordship. I need to take instruction, Lordship, here. Yes.
Lordship is currently in the transit camp, Matia, Lordship.
What is your name, madam?
Lordship, H.G. Das, Lordship, for the petition.
Heard Miss H. G. Das, learned counsel for the petitioner, who has filed this petition with a complaint that the petitioner was arrested on 28/5/2025 without any reasons, full stop. The petitioners have the apprehension that such arrest may be in connection with some FT case of which the petitioner was never served any notice. Full stop. Para? Will issue a short notice because she needs to know why she is arrested. Let notice be issued, returnable, give a returnable date here. Oh, today is 12th. We'll have it on 24th. Okay, bring the instructions
Yes, Lordship.
on 24th of November. 3 MR Adhikari 1 CGC. G Sharma.
2, 3, 5 and 6.
2,
2, 3, 5 and 6.
2, 3, 5 and 6.
Yes,
Election Commission of India, Madam S. Kotaki. 3.
Not been made party in the petition, however, in the online status, it reflects as respondent number 3.
It's still there in the petition. Item, respond number 3.
No, the DGP.
Huh?
That's
TGP,
separate.
madam.
No. You have some other copy has been served upon you. Oh, Election Commission. Madam, you should serve the same copy. Why disparity in the copies? What do you have?
Lordship, I have.
Now, what is the array of parties in your petitions?
Three is DGP. sir.
One is who? Who is what?
Union of Indian State of Assam.
Yes.
3 is DGP, 4 is DC Nagaon. 5 is SP Nagaon.
Yes, madam, you have changed this page. Your pagination is by hand and you have not given the correct page. This is not done. Other paginations are all typed. This is by hand. Yeah, 4 2. 4 5. Okay, 3 by, give correct page. 3 by S. Kotoki. And state coordinator, NRC, you have already taken.
Yes, yes.
District Commissioner P. Sharma. So let us again make the thing. MR Adhikari for 1.
Yes.
then G Sharma for 2,
2, 3, 5, and 6.
not 3.
Not three.
Oh,
3, Election Commission, 2,
oh,
4,
and 6.
6, and 7 also.
Seven.
Yes.
7.
Yes, sir.
And then Election Commission of India, 3 is S. Kotoki. And District Commissioner 5 is by P. Sharma.
Yes.
Okay, extra copies. Get a call for the recall. Take instructions. What case?
Press copy that board.
Yeah, you give me, madam.
May I please?
Yes, please.
10/6/25 order, my lord. Opinion. Is 102. Here, my lord, I have annexed as many as 6
Why
documents.
is too late in coming to the court? Oh, 10/6,
10/6/25.
25.
Yes.
Arrested.
Not, no.
Heard Sri A.I. Uddin, learned counsel for the petitioner who has put to challenge an order dated 10/6/2025 passed by the Foreigners Tribunal number 3, Nagaon, in FT case number 12 of. Why 2 FT cases?
2 initiated, both are tied
FT
together.
case and so, huh? Whereby the petitioner has been declared a foreigner post 25/3/1971. Para, let notice be issued returnable by 6 weeks. 3, MR Adhikari for 1. Election Commission of India. Yes, N. Kalita on behalf of A.I. Ali, Standing Counsel, Election Commission of India for 2. G. Sharma for 3, 4, 6,
Yes, Lordship.
7, and 8.
Yes, Lordship.
Correct?
Yes.
And P. Sharma for 5. Extra copies. Call for the records. 3. Uddin, learned counsel prays for an interim order. Para, considering the facts and circumstances, it is directed. I made a coidim, huh? Bail di bola ki condition and bail.
SP Voter Nagaon.
SP voter Nagaon.
I am obliged.
May I
Yes.
please, Your Lordship? Yes, my lord. Impugn order at page 65, annexure 11, my lord. This was passed in the year 2021. And
2021,
my lord.
what are you doing?
My lord, the petitioner is a my lord daily wage earner, my lord. He could not approach this honorable court on
Where
time.
do you work?
My lord, he has collected the certified copy on 25th.
Where is your place of work?
The place of work is at Morigaon, my lord.
What do you do?
He's a daily wage earner. my
No,
lord.
daily, what kind of work?
No, sometimes he gets work, sometimes he doesn't. My lord. Daily wage earner, as we see, my lord, normally people are doing, rendering their.
You have a family?
He has a family, man.
Yes, how old are you?
But he is, as per affidavit, let's see. He's 39 years.
Where are you born?
And I was born in, my lord, Kahikusi, Tupatuli, near Jagirot town. my lord.
You attended school there?
The school probably did not attend. my lord. There's no record.
Did not attend school. Okay, heard. Sri Hamad, Jed Hamad, learned counsel for the petitioner who has put to challenge an opinion dated 25/6, no,
9 to 21.
where is it?
9 to 20.
Page
9
65.
to 2021, passed by the learned Foreigners Tribunal number 3, Morigaon, in FT case number so-and-so, whereby the petitioner has been declared a foreigner post 25/3/1971. Full stop. Para. Let notice be issued, returnable by 6 weeks. Union of India, one is MR Adhikari, 1. Then G Sharma for 2,
2,
3,
3.
2, 3,
Three
and
and
6.
six.
2, 3, and 6, okay. Then 4 is Election Commission of India, S. Kotoki, Miss S. Kotoki, Standing Counsel. and 5 is P. Sharma. Extra copies, call for the records. 3, Hamad, the learned counsel praised for an interim order, which however has been resisted by the learned counsel for the respondents. Full stop para. Considering the above, it is directed that till the next date fixed, no steps for deportation of the petitioner be taken.
However,
Completely.
maintainability make it.
The issue of maintainability raised by the learned counsel for the respondents on the ground of delay and latches is however kept open.
My lord. Completely.
Yes,
May it please the Lordship, opinion dated is 15/12/2023, page 26, Lordship.
Mm-hmm.
23.
Yes, Lordship.
What is your name?
A.K. Hazam, Lordship.
A.K. Hazong. Okay, heard 3, A.K. Hazong, learned counsel for the petitioner,
No.
who is aggrieved by an order date, by an opinion dated 15/12/2023, passed by the learned foreigners tribunal number 1, Dhubri, in FT case number so and so silo. By which the petitioner has been declared a foreigner post 25/3/1971. Para, let notice be issued. Returnable by 6 weeks. 3. MR Adhikari, standing counsel, CGC for 1. G. Sharma, standing counsel, Home Department for 2.
2, 4, 6, and 7.
2, 4, 6, and 7. Miss S3 N. Kalita, on behalf of A.I. Ali, standing counsel, Election Commission of India for 3. P. Sharma, additional senior advocate for 5. 5 extra copies. Call for the records. 3. Hazong, the learned counsel, praise for an interim order, which is however resisted by the learned counsel for the respondents, who have also raised the issue of maintainability on the aspect of latches. Full stop para. Considering the above and balancing the equities, it is directed that till the next date fixed, no steps for deportation of the petitioner be taken. Full stop. The issue of maintainability, which has been raised by the respondents, is however kept open.
May it please, yes. Lordship, I am aggrieved by the order 22/12/2023, Your Lordship. Here I am declared as forced foreigner 1971.
Your Chakma,
Yes, sir.
I Chakma,
SK.
SK Chakma, or 3 SK Chakma. Almost same order, huh? Order date to about 22/12/2023, FP number side over. Okay, would take an action. To foreigners tribunal first. Same area of parties are the same.
No, Lordship, I am for 2, 4, 7, and 8.
9 for 1, my lord.
Okay, notice of returnable 6 weeks over again. One MR Adhikari for 1 CGC, then G Sharma for 2,
2, 4,
2, 4,
7, and 8.
7, and 8. Election Commission of India and Kalita on behalf of A.I. Alice, standing counsel. Then 5 is P. Sharma.
5 and 6.
5 and 6 P. Sharma. Okay. Baki khini ekdom ek.
Keep them.
27.
May I please, Your Lordship? My lord, by an order dated 29/5/2025, my lord, the petitioner has been declared to be a foreigner of, my lord, post 25/3/1971, my lord. The impugn order, Your Lordship will find at page number 95 onwards. my lord.
Arrested.
No, my lord, I'm outside.
You're A.I. Ali.
Anyway,
Heard three early learned counsel for the petitioner who has put to challenge an opinion dated 29/5/2025 passed by the learned foreigners tribunal Bozali in FT case number so and so, by which the petitioner has been declared a foreigner post 25/3/1971. Para, that notice be issued returnable by 6 weeks. MR Adhikari for 1, CDC 1. Then the D Sharma.
2, 4, and
Counsel
6.
home for 2,
2, 4, and 6.
2, 4, and 6. 3 District Commission is by P. Sharma. What about election officer Borpeta?
Election officer.
Election officer Borpeta. I think state will take.
Yes, yes.
G. Sharma 3 and 5. What about 7 State Election Commission? State Election Commission, I think state is R. Dubey.
Yes, yes.
Is he there in the court?
No.
R. Dubey? R. Dubey likhiba for 7. So call for the records. 3. Ali, the learned counsel prays for an interim order. Consider and has submitted that till date the petitioner has not been arrested. Para, considering the above, Amira Didima condition imposed for bail. Will grant bail on conditions. Those everything. Identification has to be ensured.
I'm obliged.
কোনটো মাতাচোন কি আছে আপডেট কি কৰিব আমাৰ সব ফাৰ্স্ট অফতে Yes, what is the hurry?
The urgency is nothing, my lord. One of my relative is hospitalized.
No, in the matter, you
Yes,
can
my
do
lord.
it
This is a habeas
sometime.
corpus petition, my lord. The mother of the petitioner, my lord, she was arrested on 23rd.
Yes, are you ready with this matter?
No, not.
Who's appearing?
In this matter, my lord, just like yesterday's matter, my lord, we have filed our affidavit. So let it be on Monday, my lord.
My lord.
Habeas corpus would like to give preference. Monday we can have.
Yes, Monday.
Monday.
Yes.
Today he has to leave early.
Yes.
Made a mention, so
Yes, my lord.
would have accommodated, but if you say Monday, we'll have it on Monday then, okay?
But there is a, my lord, one thing, my lord. There is another writ petition, my lord, by which, my lord, this earlier ex parte order has been put to challenge, my lord. And in that particular writ petition, my lord, there was a specific direction that the petitioner shall not be deported out of the country, my lord. Even then, my lord, she was deported to Bangladesh. Thereafter, my lord, she was again taken over.
Now, where are you?
Now she is in Kokrajhar, my lord, now. She was
This matter
moved
were
to
taken up yesterday.
No, my lord, other matter.
Oh,
Similar matter was
Similar
taken.
matter.
Other matter, my lord,
okay.
where we had filed our affidavit because
Yes,
we were
yes.
asked to clarify our statement.
And in fact, my lord, in the year 2019, my lord, she was continuously under detention. for
Okay,
2
we'll
years.
have it on Monday.
Monday,
okay?
My lord.
Monday, problem.
Third, this is item number
33.
heard 3 Jed Hamad learned counsel for the petitioner. Also heard 3 MR Adhikari under CGC, comma 3 G Sharma standing counsel home and 3 P Sharma learned state counsel. 3 Hamad has expressed certain urgency in the matter. Full stop. 3 Adhikari, the learned CGC has submitted that affidavit in opposition has been filed and full stop has been filed. Para, considering the above, matter is directly to be listed on Monday.
Deeply obliged.
এইটো আমাৰ নহয় নেকি?
20 আমার No, it will be.
The matter pertains to custodial death of the petitioner's son.
But it's heard by a bench for
Yes, it was
for
heard
some
by
time.
yes.
We find a long note
Yes, ma'am.
Honorable Justice Surana.
Yes, it was almost,
Let it go before that bench. I think it'll be, that bench
Lord-
perhaps next
Lord-
week it'll be available.
Lordship,
Okay.
Kesaris were called for,
Oh, not by. Why is it not by?
कि release क्यों लेनी है?
No, there's nothing, no indication as such.
Release
I
क्यों?
don't know.
Night too. Nothing. I don't know, I go to tell you, yes, South, no, there should be. That's fine, man. Mr. Bora is there in this
Yeah.
matter.
Yeah,
He's on record.
Yes, on record.
Or perhaps for the there's some notification perhaps.
Maybe, madam, that may be the AM Bora. কিবা notification এখন আছিলে।
Oh, my sister has pointed out there is a notification.
Okay.
22 matter, we can give a try. Somebody has to finish it. We can finish it off. Are you ready for the matter today?
Lordship, case diaries have come, and on last occasion, Lordship has said that case diaries were given to us, and we have seen, my lord. The otherwise, my lord, the issue is they have prayed for inquiry by the independent agency like CBI into the death, my lord. According to them, he was killed. And secondly, is my lord, compensation. That is the two prayers made in the writ petition. The case diaries are there, my lord. The North Guwahati PS case was there after his death, and UD case was, my lord, he died due to drowning in river, and UD case was registered. Diary we have, my lord. The records and affidavits. My lord,
What
the-
is your allegation, Mr. Patwari?
My lord, my allegation is that, my lord, the petitioner's son was apprehended in connection with Hajo PS case in North Lakhimpur on 2/12/2021
By police?
by police. My lord, how, by following what procedure of law he was brought to my lord Guwahati, that is not reflected anywhere.
He was arrested in a connection with a Guwahati case.
Hajo PS case.
Hajo PS case.
Hajo PS.
From Lakhimpur, he was taken to Hajo.
He was taken to Hajo, but he was kept in North Guwahati police station. And in between, he was also kept in Baihata Sariali police station. So whether there were grounds of arrest was informed to the petitioner are not known. Transit remand taken, not known, my lord. And my lord, he was not even produced before the magistrate because before completion of 24 hours, in the night of 2/12/2021, he was taken to conduct a raid party where, my lord, he said that as per the police, my lord, the petitioner's son complained of bowel movement. So they stopped the vehicle and he tried to flee. And there is a stream, the photographs, lordship will see, no adult human person can drown. My lord, they say that he drowned there while trying to flee. So, my lord, the circumstances leading to death is, my lord, highly doubtful. And, my lord, very interestingly, the IO of the case on 3/12/21, the next day, lodges one FIR and a statement to the magistrate. And two versions are given on the same day, my lord. On the first version, the name of additional SP is not there. And in the second version, he says that he was accompanied by the additional SP.
There cannot be this cannot be a minor variation, a major variation.
Major variation.
No,
because
if presence of a person, how does it make a difference?
Because, my lord,
No, your difference, variation has to be in connection with the aspect of his death.
yes, my lord. It's connected.
Availability of a person not naming or naming, will it have a material bearing?
Notified law.
If in the second he says that it's a big river, in the first he says a small stream, then these will be variations.
Yes.
Connected directly relevant to the
Why-
aspect.
why it matters, my lord, because in the first version, he says that he informed the additional SP headquarters, who subsequently come to with lights and all. In the same day, in the second version, the additional SP is present. So, my lord, and my lord, within half an hour, can a human being, my lord, drown and the body can float up? Within 20-25 minutes, he drowned and the body floated up and they picked him up from the, while the dead body was floating, my lord. Is it possible, my lord? So, my lord, I will pray, my lord, it requires some hearing and lordship will kindly fix it.
No,
on-
body floating, is that the verse, is that the finding?
Yes, that is.
See, a
it.
person may drown. It is not necessary that you recover the body only is floating. You can still recover. It may not be a very deep river or deep It may be a shallow river.
Yes,
If you,
so-
you die out of drowning, your body is there, it is expected.
Yes.
But if the finding is that it floated, then it requires the minimum time.
Okay, my lord.
If the findings are there,
My
then
lord,
you,
last time when the coordinate bench was hearing the matter, while producing the records, they produced some photographs of the stream where the incident took place. And my lord, unless my lord, the head is put in the water through a boot or pressing, nobody can die. No.
let us see the,
Photoখিনি দেখা।
ইয়াতে আছে
okay, we'll have this fixed for hearing on Tuesday next.
Yes, sir. That
Require
will be
some
better.
time. Tuesday next, okay? Heard. Tuesday morning, hearing the other fellow. Heard Sri J. Patwari, learned counsel for the petitioner. Also heard Sri Dinath, the learned senior, senior advocate Assam. Anyone else? No. The learned counsel has submitted that the matter can be taken up for disposal. List for admission hearing on Tuesday next.
Right. Deeply obliged.
May I please, Your Lordship?
Yes.
Lordship, here the petitioner was declared foreigner lordship of post 71 stream loss in an ex parte order. Lordship. Dated 2/4/2022 loss. Order is at page 31 loss.
We can take this for hearing, for disposal.
Ex parte order loss.
Yes, Lord. Lord, you may heard the matter.
Yes.
Your dear bus.
Lordship.
এইটো আহিলে নে ৰেকৰ্ডটো?
ৰেকৰ্ড বিলাক আছে। আছে।
Yes.
Lordship. The impugned order is at page 31, Lordship, staff forms. And how it has become ex parte lordship, that has been mentioned in the next page, lordship. Second paragraph. May I read the lordship that?
Yes.
Page 32, lordship, second paragraph, lordship, upon receipt of lordship. Upon receipt of the said reference, the tribunal had registered a case as referred above and notice was issued to the OP wide order dated 2011-2021 for SR fixing 28/12/2021. Thereafter, a report was furnished by the process server on 27/12/2021 stating inter alia that notice was served upon the wife of the OP, namely Azufa Khatun, at the given address, which was acknowledged by his wife by putting her thumb impression, which is evident from the report itself. It is mentioned that OP was asked to appear in person or by his engaged counsel via notice dated 2011-2021 before the learned tribunal on 28/12/2022. But on the said fixed date, neither OP nor her, it will be actually his, nor her engaged counsel had appeared. However, another date was fixed for appearance fixing 4/1/2021, but none was present on 4/1/2022. But one more chance was given for appearing fixing on 1/2/2022. Again, the result was same. OP remained absent without any step on 1/2/2022. However, for the ins of justice, one final opportunity was provided fixing 5/3/2022. As for the OP, OP remained absent without any step on 5/3/2022. Again, matter was fixed for ex parte order fixing 2/4/2022. Today also, it is on 2/4/2022, none is present. Under such circumstances, lordship, the petition has been declared as foreigner lordship. Now, lordship may kindly see the notice, lordship. Notice at page 30, lordship. If you look at the research, you have to put on a mother Indians. Next question. The number of 10, 15, 50.
Okay, what is your case?
Lordship, my case is that lordship notice, admittedly notice was served to my wife while I was not at home, lordship. I being a daily wage laborer, lordship, I used to work at Guwahati, lordship. I was not aware about that, lordship, and the lordship, the notice, lordship, may kindly see the notice is served to my wife, who is an illiterate person, and notice is in English language, lordship. She could not understand the contents of this notice, lordship. And somehow he could not inform to me, lordship, also regarding this notice, lordship. And accordingly, I could not, lordship, appear, and since I had no knowledge about the proceeding, lordship, and finally, lordship, after granting 4 opportunities, lordship, finally, lordship, the imperial ex parte order has been passed, lordship. Otherwise, lordship, the documents, I have sufficient documents and other evidence, lordship.
It's not inspiring confidence.
Lordship.
Your explanation is not inspiring confidence at all.
Lordship.
Even if we accept what you are submitting,
Lordship.
your wife is illiterate.
Yes.
You are illiterate.
Lordship.
You are at Guwahati
Lordship.
at that time. You admit that the notice, some
Yes.
paper was served upon your wife. Wife doesn't know. But it is not the case that it was served in pursuance of a report of 27/12, and on the next date, the impugned opinion has been passed.
On the not on the next date, lordship.
At
But-
least 3 more dates.
Yes, lordship.
You have a paper with your hand of a foreigners tribunal, and you neglected.
Not neglected, lordship. Actually, I have no knowledge, lordship, and
The paper was given to your wife, you admit that.
lordship.
She is not literate, she doesn't know, but she has given the paper to you.
But lordship, it is the mandate of the law, lordship, that notice has to be served in English, lordship, and lordship's official language of the state, lordship. And since, lordship, it has not been served in Assamese language, lordship.
Let us see that provision.
Lordship, there is provision, lordship.
Let us see.
Citizenship. In order, lordship, in the foreign tribunal order, lordship, there is provision, lordship, and in the full bench judgment also, lordship, that has been mentioned, lordship.
Let us see the. Which provision?
Lordship, find that clause 3 lordship, procedure lordship, plus 3, 4 lordship. Plus 3, 4 lordship, surplus 4 lordship.
Yes. In English as well as the official language.
Official language of the state lordship.
Yes, let us see where is the notice?
Lordship, notice it as at page 30 lordship.
Page?
Page 30 lordship, 30 lordship.
Giving the official language as well as and believable. Even the contents of the notice to the same.
Even otherwise, lordship, if I had knowledge, lordship, I will appear, lordship. Even otherwise, lordship, if I had knowledge, lordship, I will appear, lordship. But this notice.
You cannot drag a proceeding. Then the entire aspect of proceeding ex parte will be redundant. If all proceeding which is ex parte have to be interfered only because it's done ex parte, what recourse will an adjudicating authority have if a person doesn't appear? You cannot wait till indefinite time.
Lordship, I had that explanation that I could not, lordship, since I was not present. If I had been present in home, lordship.
We are checking the LCR.
Lordship.
Let us see the report of
And otherwise, lordship, my mother is also been declared as Indian, lordship, in a separate proceeding, lordship. That records of that case has also come, lordship. So, lordship, if lordship an opportunity is given, lordship, I would prove my citizenship, lordship.
That's precisely.
I have come to know only in the month of December 2024, lordship, about the impugned order, lordship.
একটু হেৰি কৰিছে একচেপ্ট কৰিছে লগ নাপায় তেখেতৰ ঘৈণীয়েকক লগ পায় ঘৈণীয়েকৰ আদি অন্ত ভালকৈ বুজায় আদি অন্ত ভালকৈ বুজায় Open it up. Yes, Mr. Sharma.
Lordship will kindly see clause 5B of Foreigners Tribunal order. If the proceeding is not found at the address at the time of service of notice, the notice may be served on any adult member of the family of the proceeding and it shall be deemed to be served on the proceeding. 5B.
No, he is on the contents.
Loss.
He is on the contents.
In Muslim Mondal case also, lordship, that observation is there, lordship.
3.5b, you are on the 3.5b.
Yes,
We
lordship.
have also seen that. My sister has pointed out.
Yes,
But
lordship.
his, Mr. Abbas's point, his entire edifice is on on subclause 4.
Yes, Lordship. Shall be served in
Notice
English
shall be served in English and
also.
in the official language of the state, indicating.
Otherwise, Lordship, reference was initiated in the year of 2001, Lordship. IMDT reference, Lordship. Proceeding is very much aware about the proceeding, Lordship. And Lordship, I think, Lordship, there is no infirmity in the opinion passed by the learned tribunal. And another,
No,
as-
only on the aspect of notice,
yes, Lordship.
whether ex parte can be proceeded.
Hmm? And also in official language of the state, indicating the burden is on.
Paragraph Lordship 103.
Hmm?
103.3 Lordship, Roman 3. In that point, Lordship, which you mentioned, Lordship. Page 63 of this agreement. It's in the bottom.
103.
103 sub, Roman 3, sub 3. Where it is also mentioned that in both languages it should be Lordship.
Please read, please read.
Lordship. The notice shall be issued by the tribunal in the official language of the state, also indicating that the burden is on the proceedee to prove that he is a Indian citizen or not a foreigner. As specifically mentioned that official language of the state law.
No, but then we can have to
Lord.
have to put some other questions to you.
Lordship.
See, if you are basing your argument on the language employed in the notice, it has to be have a connection with the prejudice you have suffered, that you have not understood,
Lordship.
that the burden is upon you to discharge. It will not mean that you are not aware of the proceeding.
Lordship, since I was not, that the order itself, because I was not present at home, Lordship.
No, that can be served on any adult member. That
No,
has been taken
I'm
care of
not
by
on-
the other
Lordship.
provisions.
No, I am not on that it was not served, Lordship.
No, you have already said
No,
it's served.
Lordship.
You are on the
And-
contents,
My lord.
that it has to be also in the official language.
Language.
What is the objective? Objective is that you
To
should
understand.
you should understand.
Lordship.
That will not be a cause not to appear in the tribunal.
Because if I don't understand what the case and where, what is the date fixed, Lordship.
The report of the officer, process service is there. Everything has been explained to your wife.
Lordship, that is there, but she is in the order itself that she is an illiterate person and put thumb imprison, Lordship. And
It has been explained to you.
Lordship.
The process server has said it has been explained to everything. Has been explained to you.
Otherwise, Lordship,
The aspect
document-
that the burden is upon you, that is what is the intent of the notice.
Lordship.
The proceeding, the fact of the proceeding, you are aware. You may not be aware that the burden is upon you.
Lordship.
That is not your case. Your case is simply that the contents should be in official language, it is not there. Factually, you are correct, but what is the objective? That it should be in official language. That you should be aware there is a proceedings.
Lordship.
If it was served on somebody else, you are not at all aware, you know that there is a proceeding.
No, actually, in fact, I was not aware because I was out of station, out of the home, Lordship. And Lordship,
That is the question you have put.
Lordship,
This notice was,
I have stated in
no,
paragraph
notice was served in pursuance to the order dated 2011-2021.
Right.
Thereafter, the matter was fixed on 28/12. You did not appear. 4/1 did not appear. 1/2 did not appear. 5/3 did not appear. 2/4 did not appear.
Had it been I aware, Lordship, I will appear, obviously, Lordship.
See, it's not a case that from Guwahati, you have not come to your place for the last 4 months. That is not your case.
And otherwise, Lordship, the documents are available and my mother was also declared Indian. So, Lordship, one chance may be given, Lordship.
So you had a good case, you should have fought out in the tribunal. You took a chance. You took a chance.
The
You
last,
definitely took a chance.
one
Let us see.
last opportunity may be given, Lordship, so that I can, Lordship, that record has also been called, Lordship, in the mother's case, Lordship.
We have seen the records. See, these are references, as you know, it is a double-edged sword. In this case, you can say mother was declared an Indian citizen. If the other case, somebody is declared a foreigner, still we say that the other family members cannot be declared foreigners unless you have a separate reference. So that is not going to help you a lot. Some other member declared or not declared is not, your case has to be decided on your own merits. That is the right which is given to every person against whom there is a proceeding.
I have to contest, Lordship, that proof that contains that whether my legacy is there with the person who has been declared in Indian Lordship and my mother Lordship. So I just seek, Lordship, one opportunity, Lordship.
Just take a reverse thing. Family member, father has been declared foreigner.
Yes.
Will you make the same submission? I'll prove my legacy with my father who has been declared foreigner.
No, Lordship, in
Then you'll say, no, I'll have to prove my case on my own. You cannot take up this kind of submission. It will go against you. In the next case itself, it will go against you. And therefore, we are making clear that all cases will be decided on its own merits. Whether your other family member is a foreigner or not, unless there's a reference proved in a duly appointed constituted tribunal in accordance with law, we are not going by that.
From 71, Lordship, my parents' name appeared and with my mother's name also appeared, Lordship.
You did not contest. How can we help you? Yes, Mr. Adhikari, what do you say?
Further, my lord, it is not his case.
No, we are not on mother, we are on the notice part.
Notice part, my lord, what I am trying to submit is this, my lord. But he has made out a case that, my lord, about the language, the contents of the notice. But what I am trying to say is, my lord, he is not saying, he has not made any statement that, my lord, the notice or a sheet of paper which his wife received, well, that was not informed to the detainee, not that person, my lord, the evicted person. That is not his case, my lord.
That we have stated to him.
Yes.
I've stated in paragraph 19, Lord.
What have you stated? Page, Mr. Abbas?
Page 17, Lord.
Page 17?
Yes, Lord. Paragraph 19, Lord.
Paragraph?
19, Lord.
No, you have admitted that it was served upon your wife. You cannot make alternative statements in the same, contrary statements in the same petition.
Thank you.
Petitioner's wife is also completed. Raising facts of law. So. I said the point, I look.
No, he has not said that. There's no such statement that my lord, his wife did not inform him. No. In paragraph 19 there's no such statement.
I have stated that I am not aware of it.
You are not aware, but you have not said that your wife did not inform you. That's what I'm saying. You should have been, there should have been a specific statement that, my lord, The wife didn't inform him about that proceeding or the notice received by her.
No, Mr. Adhikari,
By
the petition has been structured in a very crafty manner.
her.
This submission of yours may not be correct in terms of the pleadings.
I'm just on.
No, what Mr. Abbas has candidly said that he admits the wife has, but it's not a part of the pleadings.
Yes.
Pleadings have not stated, we are trying to research.
Yes.
If it is there, kindly assist the court. There is no statement that the wife has received. It's a different matter that he has conceded, but it's not a part of the pleadings. He's not bound by that. If there is any other statement, kindly take us to that statement. When did you come to know about this opinion?
In the month of December 2024, Lordship. When
24.
police has informed me, Lordship, from Avali PS, Lordship.
That was informed in official language or English language?
No, Lordship, that's verbally language.
Verbal language.
Yes, verbally informed.
That
And
you have understood. Even if it is in English,
Lordship,
you'll understand that.
Immediately I have obtained the certificate copies of notice and orders, everything, Lordship. Then I have filed before this petition, Lordship.
Mr. Adhikari, Mr. Sharma, please try to find out if there is any statement admitting that the wife
Yes, madam.
has received the notice.
I have come to know from the orders, certificate copies of the documents, Lordship itself, Lordship.
Your bona fide is questionable, Mr. Abbas.
Lordship, it's my instruction, on instruction, Lordship, I have.
Bona fide is highly questionable. You're approaching a court of equity without clean hands.
Nothing, Lordship, conceal, I have, Lordship. I'm not seeking, Lordship, only one opportunity, Lordship, so that I can do file.
Yes, can you impose costs?
You also wanted to remand the matter.
If we, it cannot be for granted.
Yes.
Has to be on some cost.
Exemplary cost should be imposed, so that when this ground is not taken up by anyone else.
He is a poor man, Lordship.
That is what we're thinking. You are a poor man. But poor economically. But you have taken a very important point. That is not poor point. You have taken up a very rich point. Okay, please write it.
Strictly.
Very good.
The instant petition under Article 226 of the Constitution of India has been instituted challenging an opinion, public order dated 2/4/2022, passed by the learned Foreigners Tribunal number 10, Borpeta, in FT case number so-and-so, cited. By the impugned order oblique opinion, the petitioner has been declared a foreigner post 25/3/1971. Full stop. The primary ground of challenge is that the order is an ex parte one, whereby the petitioner was deprived of a fair and reasonable opportunity to defend himself. Full stop. Para. As per the facts projected, comma, a notice was issued by the Foreigners Tribunal on 2011-2021, returnable on 28/12/2021. Full stop. The petitioner works, however, has his place of work at Guwahati and has to remain out of his residence. Full stop. It appears that the notice was served on the wife of the petitioner, and in this regard, the process server has made a report on 27/12/2021. Full stop. However, on the returnable date, i.e., that is 28/12/2021, the petitioner did not appear. Full stop. The learned tribunal had thereafter given further chances of appearance and contesting, and the case was fixed on 4/1/2022, 1/2/2022, 5/3/2022, and 2/4/2022, on which date the matter was taken up for final disposal. Full stop. Para. We have heard Sri J. Abbas, so and so, huh? You take it on. Sri Abbas, the learned counsel, has primarily based his argument on the aspect of the notice issued by the learned Foreigners Tribunal. Full stop. By drawing the attention of this court to order 3 within bracket 4 of the Foreigners within bracket Tribunals bracket close order 1964 within bracket hereinafter referred to as order of 1964 bracket close. He has submitted that the contents of the notice has to be in English and also in the official language. Full stop. He submits that certified copy of the notice was procured after the police had recently informed the petitioner about the opinion, from which he has come to learn that the contents of the notice is not in the official language. Full stop. He has also contended that both the petitioner and his wife are illiterate person, and even if it is assumed that the report of the process server is correct regarding furnishing of the notice to the wife of the petitioner, the same would not mean a compliance of the aforesaid provision of law. Full stop. He has submitted that there are good materials to defend his case, provided he is given a chance. And those materials also include an opinion which was rendered in favor of his mother, against whom a proceeding of similar nature was initiated. Full stop. Para. Sri D. Sharma, learned State Council, learned Standing Council, has, however, strenuously opposed the writ petition. Full stop. He has submitted that though there is a requirement under the law to have the contents of the notice also in the official language, there is no clear pleadings in the writ petition of denial of receipt of such notice. Full stop. He has also submitted that it is not the case of the petitioner that on the returnable date itself, the matter was taken up for disposal, and the learned tribunal had given at least 5 more dates so as to enable the petitioner to contest the case. Full stop. Para. Sri Adhikari, the learned CGC, who has endorsed the submissions of Sri Sharma, the learned standing council, has added that even if the petitioner even if the case projected by the petitioner that he was not aware of the contents of the notice is examined, it will not mean that the petitioner was not at all aware of any such proceeding. Full stop. He has emphasized that the aspect of the notice being also in the official language was only to indicate that the burden is on the proceedee to prove that the proceedee is not a foreigner. And as such, the aspect of a proceeding pending cannot be ignored or overlooked. Full stop. Para. The rival submissions have been duly considered, and the materials placed on record, including the TCRS as to Huru, have been carefully perused. Full stop. Para. Since the primary ground of challenge is based on Order 3 within bracket 4 of the orders of 1964, the aforesaid provision of law is extracted herein below. Full stop. The requirement of law is that the notice shall be served in English and also in the official language. Full stop. There is also a requirement that such notice has to indicate that the burden is on the proceedee to prove that the proceedee is not a foreigner. Full stop. We have, however, also noted that there is a provision that when a proceedee is not found to be present at the time of service, such notice may be served on any adult member of the family. Full stop. Para. The records of this case, which have been transmitted pursuant to orders passed earlier, would however show that the notice was indeed served on the wife of the petitioner who had affixed her thumb impression. Full stop. The aforesaid receipt is also supported by a report of the process server dated 27/12/2021. Full stop. We have, however, noticed that the language employed in the notice is English, and there is no other notice in the official language. Full stop. Para. The aspect of the requirement of the contents of a notice to be in official language is only to ensure that no prejudice of any nature is caused to a proceedee in defending himself or herself in a proceeding of this nature. Full stop. In the instant case, the petitioner has made a statement that both he and his wife are illiterate. Full stop. Though there is some force in the arguments advanced by the learned counsel for the respondents that the ground taken by the petitioner may not be enough to come to a conclusion that the petitioner was not aware of the proceeding at all, we are of the view that that in the instant case, there is some aberration of the requirement of law under Order 3, within bracket 4, full stop, para. We have, however, noticed that in spite that despite the aforesaid ground, the learned tribunal had given 5 further chances to the petitioner to appear and contest the case, which the petitioner appears to have been ignored, appears to have ignored, full stop, para. Considering the facts and circumstances, we are of the view that while the petitioner would be entitled to some relief, that has to be subject to certain cost, full stop, para. Accordingly, the impugned opinion dated 2/4/2022 rendered by the learned foreigners tribunal 10th Borpeta in FT case number so and so is set aside, full stop, set aside subject to payment of cost of rupees. We give a minimum cost 5,000 to be paid to whom?
District Legal Service Authority or
Legal
District
service, huh?
District Legal Service Authority.
District Legal Service has got enough money. Your bar needs money. Benevolent fund. Okay. Lawyers Benevolent Fund. I'll give the account. We also direct the petitioner to appear and file the written statement before the concerned foreigners tribunal on. We'll give a date, Ms. Abbas. Today is 12th. We'll have it on 25th, along with a certified copy of this order, whereafter the learned tribunal would take charge of the proceeding and complete the same expeditiously and in accordance with
314.
Order 314 of the orders of 1964. Writ petition accordingly stands allowed in the manner indicated above.
Obliged, Lordship.
LCR, and back the TCR forthwith, along with a copy of this order. First date of the disposal. This LCR Hanatil, no? না আজ আজ ঠিক আছে নয় তো কত মিস হয়ে যাবো না আপনি মিস
My lord.
Yes.
Ex per the opinion, my lord. Page 20, the relevant portion, page 22, my lord.
Records have come.
My lord, yes, my lord.
What is your name? Aman.
Yes, my lord.
Yes, ready for the matter, Mr. Sharma? Which tribunal?
This is, my lord, Foreigners Tribunal, Barpeta number 7.
Okay, we take it up for disposal. AW Aman.
My lord.
Yes.
So the relevant portion, my lord, page number 22. Notice was not served, my lord.
Notice was not served.
Not served. My lord.
Let us see the opinion.
My lord, page number 22, the relevant portion.
20.
22.
It starts at 20.
It starts 20, relevant portion 22, para number 7, my lord.
FT. So, yes, please, page 22.
22, para 7, my lord.
Para 7.
My lord.
Notice was issued.
Notice was not served upon the petitioner. May I read, my lord?
Yes, yes, please.
My lord. It says, accordingly, after registration of the case, notice was issued to the OP to appear and to file written statement and to produce evidence in support of his citizenship. After service, notice returned with service report. On perusal of the service report,
Office
is
of the Gaon Bura.
my lord.
Yes, we have dealt with the matter, but you contemplate a situation
Yes, lord.
where a notice is being sought to be served. The person is not there. There was one place where he had last resided, but he had left the place one year back.
Yes, lord. Please.
So
Without
will it-
intimation,
Huh?
without intimating the investigation.
No.
agent.
See, what is the objective of affixing a notice in the last known place of residence? So that he comes back and he sees.
Yes,
But
yes,
suppose he has left permanently,
yes, lord.
or maybe with the intention not to come back to that place,
Yes.
and that place is under the occupation of somebody else. Then what is the difficulty in serving a notice to the in the office of the Gaon Bura, which perhaps would be a better
Yes,
mode
yes, yes.
to make him aware that the Gaon Bura
Yes,
can inform
lord.
him.
Yes, yes. Yes.
You are not applying your mind in that direction. This can come from you.
Yes,
This may
lord.
be matters of consideration.
Yes, lord, sir. But in my case, what happened, my lord?
Just a minute.
My lord.
See, if you go by the provisions in the CPC,
Mm.
it is in sync with the CPC. But here the matters are completely different. A person is proceeded on the apprehension that he's a foreigner.
Mm.
Likelihood of he absconding is much more. He may not come back to he may not
Yes,
come back to the same place. So serving in the office of the Gaon Bura
Mm.
is perhaps a better option to make him aware, because the intention, what is the intention? That it should not be an ex parte. The objective is to make your best effort to make him know that the proceeding has been initiated against him.
Yes, lord, sir.
Otherwise, there was no provision for issuing notice. Register, declare. That's not the. You have to give him a fair chance. So how do you give him a fair chance? Issue a notice, he is not there. If you serve in a place, he is not there, but affixing a notice, he never comes back.
Yes,
And
lord.
law says that deemed served. দিয়াটো ইনকৰ্পৰেট কৰিব লাগে দিয়াটো এটলিষ্ট ভিলেজ হেডমেন হওক বা মৌজাদাৰ হওক বা কিবা হওক additionally, but there has to be a finding that we have tried. See, without even hearing in detail the learned counsel, we have already framed our opinion in one of our cases, which you have disposed to this morning. The same ground, this will also go. We'll have to allow this.
Yes, lord, sir.
But I think it's high time
Yes,
to
yes.
think over. Because this recourse taken by the process server may not be an unreasonable recourse.
Yes, yes, lord, sir. Yeah.
There may not be a last, he may not know where he last resided. The house may be demolished, it may be in the occupation of somebody else, it may be renovated, it may be restructured.
Yes, lord.
The purpose of affixing the notice in the last known place is with the assumption that he occasionally comes back there and he sees the notice. And people in the locality will see the notice, may can inform him. But same thing can be done by the Gaon Bura, who would be in a much better place to know where he is presently there, residing. That is the only case that it was given to the affixed in the office of the Gaon Bura. That is your case.
No, my lord, my case is that the part of the village where I was residing got eroded in the Brahmaputra.
No, that's besides the point. But notice was not served upon
No,
you.
no.
It was served in the office of the
Of
Gaubur.
the Gaubura.
We'll allow this,
My lord.
which.
His wife's case was also set aside on similar.
Exactly, we'll allow this.
My lord, deeply.
But we'll give a date.
My lord.
We'll give a date since you are aware. We give a date. Which FT is there?
This is Barpeta 7.
Barpeta 7, we'll give the same date.
My lord, the wife's case is on 1st of December. Maybe listed together. Similar case, my lord. This,
1st of December, we'll pass separate orders.
my lord.
Okay, you appear on 25th.
My lord, my lord.
Of
I
25th,
love
December, madam? 25th. 25th. Was it 25th?
My
You
lord.
have to appear along with WS.
Yes, my lord.
Along with WS and a copy of this order. Thereafter, the proceeding will be completed by the tribunal.
Please, your lordship.
Send back the LCR to you.
As per 314.
Huh?
As per 314.
Yes, 314, everything. It would correct PCR credibly. No, नाम को लिखी बाहर. AW Aman, B Sharma, Amavati Parikandi. No, look. This is a very good. Yeah, for example.
My lord.
Thirty-two is yours. Yes, what is this?
This is the contested case, my lord. Impugned order, my lord, page number 38, my lord. My lord.
Mr. Sheikh, which matter are you waiting for? 39. 39, you can come in the second half. We will take some time in this matter. We are going for disposal of this matter.
My lord.
TCR has come. Yes, opinion.
My lord. Here, my lord, the merely.
You're an intern, madam. Have a seat. Don't stand. There are seats vacant. Which page?
The page number 38, my lord. 65 document of the father.
What is the date of the
Oh,
opinion?
impugned order, my lord, date is 18/3/2023.
18/3.
Yes, my lord.
Three 23. Which FT?
This is my lord,
Bozali.
Bozali.
Yes.
My lord. Now, my lord, the father's name is Nayamia, which is page number 52, 1965 document, village Barbala.
What is your name?
Sahar Ali.
SAHAR.
Yes, my lord.
$52.
52 is 1965 voter list.
Where is the vernacular? 53.
Next page, my lord.
We'll go by the vernacular.
It's 53, yes.
$1965 voter list.
My lord. Barbala, his place of birth of the petitioner.
Nayamia.
Nayamia.
And father's name Malikuddin.
Malikuddin.
Nayamia is your father.
Father, my lord.
Okay, what is your date of birth?
61 years old. Date of birth is specifically not.
You are 61 years
61
presently.
years.
When did you attain the age of franchisee?
My lord, his name is first recorded in page number in voter list of 1989.
1989, you were of how many years?
He was as recorded as 29 years.
29.
29.
And earlier to that?
Uh,
That is the first voter list.
That is the first voter list. on record.
1989.
Before that, no, 21 was the age. In 89, he became 18, my lord.
Any explanation why the earlier voter list did not have your names? Okay. Yes, then Naya, okay, 65, your father is there.
Father is there, 70, father is there, my lord.
70 is what page?
Page 55 is the vernacular, 54 translated.
70. Nayamia.
My lord.
Yes.
My lord, and page number 59 is the 1989 voter list where the petitioner name is recorded for the first time along with his father. Same voter list. The village remains the same, Borbala.
What is your name? Samar.
Sahar Ali at
Sahar.
610 serial number.
Yes.
My lord. Now the next voter list, my lord, is 1997.
Page?
Page number 62. This is in English. So the father name is there, this house number 741, and the next annexure, Shahar Ali's name 742, house number. So in two separate voter list, in two separate home, but same location, my lord.
In 63, your name is not there.
64, my name is there in the 1997 voter list only, but house
Yes.
number is different. 741 father, 742 is the petitioner. Here, my lord, the grandfather name is Manek. This became one of the reason why he was declared a foreigner. It's supposed to be Malek, but it's written as Manek here.
Yes.
Now, 64 is petitioner's name.
60? Five.
Page number 64. Page number 64.
Not 64, 65.
65 minutes. Starts on 64.
Yes.
This is the next house number, my lord.
Yes.
And then here the father dies, my lord, 1997. So the next voter list 2005. Page number 67, my lord.
Where is the wife in the voter list of 1997? Your wife?
Her name is not there. This is a standalone voter list, my lord. Her name is not there.
No, in the voter list of 2005, your wife is also there with you.
Yes, my lord. Probably he just applied for himself. I'm just guessing, my lord.
See, Mr. Aman, we are more interested of the voters list of that crucial relevant period. Post a particular year, we may not be too much interested. Yes, you may rely to build a linkage with your parents, but we are more interested of that period, crucial period, where your names of the parents are there and we need to show a link. See, you are presently aged about 61 years. So you must have attained the age of voting when? In sometime in the year 1980. How much? If it was even 21, 80 होगा ना, 80? 61 or 80 होगा?
85, my lord.
Huh?
85.
85.
85.
But your first voting, not 85, before that. In 1989,
Yes, yes.
you were stated to be 29 years.
Little.
At least on 1981.
81, yes.
1980. You're correct, 1980. There's no voters list of yours from 1980 to 1989. There is one lacuna I have to answer. What is the primary grounds of the tribunal to declare you as a foreigner?
My lord, one of the primary ground is page number 43, my lord.
43.
43.
Yes.
Para 22, my lord.
Yes,
May I read, my lord?
22.
Para 22, my lord.
Yes, please. Which part?
But if you compare with the age of the Nayami and Hetan Nessa, whose names appeared in the voter list of 1965 and 70, and Nayamia and Hetan Nessa, whose names appeared in the subsequent voter list, that is 89 and 97, it cannot be said that they are the same person. In the voter list of 1965 and 70, the age of Nayamia and Hetan Nessa are found to be inconsistent. So in 1970, the age of Nayamia is shown as 56 years, but in the voter list of 1989, the age of Nayamia is shown as 84 years, which goes abruptly high, in as much as if Nayamia was 56 years of age in 1970, after 19 years of age, should have been 75 years instead of 84 years. Similarly, the age of Hetan Nessa had been up by 15 years. If Hetan Nessa was 40 years of age in 1970, her age should have been appeared as 59 years in the voter list of 1989 instead of 1974. Thus, there is a difference of 14 and 15 years in the age of Nayame and Hetan Nessa in the voter list of 1970 and 89, which is just unacceptable. For ready reference, the content of the voter list of 65, 70, 89, 97 are reproduced below. Then 23, that apart, it stated the name of the grandfather is Malikuddin, as shown in the voter list of 1965 and 70 against the name of the projected father. But in the voter list of 1989, the name of his grandfather is shown as Malik instead of Malikuddin. The important aspect of this case is of the OP that all the age of the parents were wrongly shown in the voter list of 89 as 84 and 74 instead of 75 and 59 years. And the name of his grandfather was wrongly shown as Malik instead of Malik against the name of his father. In other words, no such plea is taken by the OP either in written statement or evidence. Thus, it is an admitted position of the fact that the age of his parent and the name of his grandfather, as shown in the voter list in 89 and 97, are correct. So largely on this ground, and then the Gabura submitted deposed before the learned tribunal, but he did not bring the ID card. So may I read para 21, Mila? Coming to the voter list produced by the OP in order to establish the linkage with his projected father, the first voter list of 1989 Exhibit C, which contains the name of 10 voters, namely Nayamia at serial number 604, Hetan Nessa at serial number 605, Omar Ali at 606, Hanufa Begum 607, Al Mahmood serial number 608, Sahila Khatun serial number 609, Sahar Ali serial number 610, Shukurjan Nessa 611, Samsuddin at serial number 612, and Basarat Ali serial number 613 purportedly. Exhibit C shows that the name of the OP appeared in the voter list of 1989 along with his father and mother, whose name appeared in the voter list of 1965, Exhibit A, and 70 Exhibit B. And therefore, the link of the OP and his parent has been established. And being the son of an Indian parent, he is an Indian by birth.
মানে কিন্তু কি বলে ডিস্টারবেন্স গুলো বহুত কম আছে। সিবলিংসৰ কথা কিছু কৈছে নেকি? আৰু হেৰিত আহিছে নেকি এইবিলাকত? ভোটাৰ লিষ্টত আহিছে সিবলিংৰ নাম? Who are the witnesses, Mr. Aman?
My lord, his brother DW2 and the Gaubura DW3,
3 witnesses,
including him 3.
3. So petitioner, the brother and the Gaubura. Gaubura did not have an identity card. That was
Yes.
one of the
That was the
reason
reason
of
why.
discarding.
My lord.
And how many siblings do you have?
Siblings, 5 siblings, lord.
Their names are appearing in the voters list.
Yes, my lord. It's 5 brothers, sisters, 1, 2, 5. I think 8 brothers and sisters. 5 brothers, including the opposite party, and 3 sisters, my lord.
You have any son, daughters, children?
Yes, my lord. Children. Two children, my lord.
No, it's on page 68 or 7.
2 children, my lord.
Yes. Okay, we'll come back at 2 o'clock. Mr. Sharma, what do you say?
Lord, I will make my change on it 2, lord.
Is there any major inconsistency?
Lordship, yes.
Yes. Okay, we'll consider 2 o'clock. Yes, Mr. Sharma.
Lordship, my humble submission is that there is no infirmity in the opinion passed by the learned tribunal, lordship, and lordship, only link document is 1989 voter list, lordship. Apart from that, there is nothing to link with his projected parents whose name appears in the voter list of 1966, lordship. And lordship, voter list is not enough, lordship, to establish one citizenship, lordship. And regarding that, our High Court has settled the position in Aziz Mia's case, lordship. Aziz Mia's case, I am relying para 14 WPC 2370 of 2023. WPC 2370 of 2023.
Name?
Name AZIZ, Aziz MIYA, Mia, alias MD Aziz Mia, AZIZ MIA. Para 14, what it says, lordship, I am just reading.
The order dated?
Order dated, lordship, 9/6/2023. Para 14, I am reading, lordship. we are constrained to observe that mere claim by a suspected person by referring to a voters list, claiming a person therein to be his father is not a conclusive proof, and that by doing so, the person has discharged the burden that he is not a foreigner. This is because there is also a further requirement to prove that the person who is reflected in the voters list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with further materials acceptable in law. So, Lordship, my humble submission is that voter list is not enough, Lordship. And Lordship, regarding voter list, Lordship, in para 22, page 43 of the writ petition, Learned Tribunal has discussed the discrepancy content in the voter list, Lordship. Para 22, I am reading, Lordship. Page 43 of the writ petition. But if we compare with the age of Tayamiya and Hayatan Nessa, whose names appeared in the voter list of 1965 and 1970, and Nayamiya and Hayatan Nessa, whose names appeared in the subsequent voter list, that is 1989 and 1997, it cannot be said that they are the same persons. In the voter list of 1965 and 1970, the age of Nayamiya and Hayatan Nessa are found to be consistent. So in 1970, the age of Nayamiya is shown as 56 years, but in the voter list of 1989, the age of Nayamiya is shown as 84 years, which goes abruptly high in as much as if Nayamiya was 56 years of age in 1970, and after 19 years, his age should have been 75 years instead of 84 years. Similarly, the age of Hayatan Nessa had gone up by 15 years. If Hayatan Nessa was 40 years of age in 1970, her age should have been appeared as 59 years in the voter list of 1989 instead of 74 years. Thus, there is a difference of 14 and 15 years in the age of Nayamiya and Hayatan Nessa in the voter list of 1970 and 1989, which is just unacceptable. So, Lordship, regarding discrepancy of voter list, Lordship, our High Court has already settled the position, Lordship, in Basiran Bibi's case, Lordship. It was a reported case, Lordship. 2018 1 GLT 372, Basiran Bibi versus Union of India.
Please, please.
Lordship, 2018 1 GLT 372. Para 30.
What is the proposition?
Para 30, just I am reading, Lordship. Reliance placed in the case of Abdul Matali, alias Matlab Muhammad Supra, can be of no assistance to the petitioner in as much as it has already been clarified by this court in previous decisions that the said decision did not lay down any law and was a decision confined to the facts and circumstances of the case. Regarding discrepancies in the voters list, which the petitioner contended were not her creation, being entered into by officials of Election Commission, and therefore should not be used adversely against the petitioner, such contention is without any substance. The voter list were adduced as evidence by the petitioner herself to prove her case that she was not a foreigner but a citizen of India. Petitioner cannot insist that only that portions of the voter list which are in her favor should be accepted and those portions going against her should be overlooked. This is not how a document put forward as a piece of evidence should be examined. The document has to be appreciated as a whole. And Lordship, apart from that, Lordship, if voter list has gone, Lordship, only things remained is that Lordship brothers' evidence and Lordship Gaubura's evidence, Lordship. And regarding brother's evidence, Lordship, what learned tribunal has discussed, Lordship, in page 47, Lordship.
Brother is
28,
DW?
2. Page 47, para 28. In the case in hand, OP has not even taken the plea that the name of his grandfather and the age of his father and mother were wrongly recorded in the voter list of 1989 and 1997. Rather, DW2, namely Basarat Ali Ahmed, who has appeared as the brother of OP, has corroborated the fact that his father Nayamia died in 1997 at the age of 91 years. It is to be remembered that age of Nayamia, son of Malek, was recorded as 91 years in the voter list of 1997. If this statement of DWT is taken to be correct, Nayamia, whose name appeared in the voter list of 1965 and 1970 at village Borbala, was a different person in as much as he was 51 and 56 years of age in 1965 and 1970, and accordingly, he cannot die at the age of 91 years in 1997. Another aspect to be noticed at this stage is that DW2, namely Basarat Ali Ahmed, adduced evidence in support of OP as the younger brother of OP. DW2 has filed his examination in chief on affidavit on 14/12/2021, wherein he enclosed one annual Kiraspatta in the name of his father, elector photo identity card of his own, along with his admit card of HSLC exam, school certificate issued by the headmaster of Kalzar, a Helanar Pam, Itarvita government aided HC school. As stated in para 5 of his evidence, DW2 claims that his own name has been recorded in the voter list of 1989 Exhibit C, along with his parents, brothers and sister-in-law at village Borbala under 46 number Surukhetri LAC. A perusal of Exhibit C would go to show that the name of Basarat Ali could be seen at serial number 613, showing his age is 20 years. In the elector photo identity card, which is marked as Exhibit J, and all testimonials of his educational qualification, his name is shown as Basarat Ali Ahmed. His date of birth is shown as 1/4/1973. In the admit card of his HSLC examination, the headmaster of Kalazhar Helanar Pam, Itarvita government aided HC school, certified that his age on 1/3/1989 was 15 years, 11 months. The age of DW2 as appeared in the admit card of HSLC exam, school certificate and elector photo identity card is found to be consistent, but the same is found to be totally inconsistent with the age of Basarat Ali, whose name appeared in the voter list of 1989. If he was 15 years, 11 months as on 1/3/1989, he was not at all eligible to be a voter in 1989, in as much as during that relevant point of time, the qualifying age of a voter was 18 years. Prior to that, qualifying age of 21 years, which was reduced to 21 years to 18 years in 1988 for voting elections to Lok Sabha. So Lordship. Then Lordship, para 30 I am coming. Similarly, in the voter list of 1989, the name of Umar Ali and Lal Mahmud, along with their wives, namely Hanufa Khatun and Sahila Khatun, also appeared, who claims to be the brothers and sister-in-law of OP. During cross-examination by the state, OP was asked about the wives of the said Umar Ali and Lal Mahmud, but he could not name his own sister-in-laws. Thus, both OP and DW2 have failed to prove that it is them whose names appeared in the voter list of 1989. Then Lordship, if brother's evidence has been discussed, Lordship, and then Lordship, here Lordship Gaubura's evidence also discussed and it was totally based on personal knowledge. So it cannot be accepted as valid piece of evidence that must discuss in the opinion Lordship. And if
To have personal knowledge, how it can be discarded? You can
yes,
have a
Lordship,
personal
it is
knowledge
settled
of
law.
things.
It is settled Lordship, because our High Court has on previous decision has so many decisions has been passed regarding that Lordship. One of that is Lordship WPC 1073 of 2016, Muhammad Abdul Quddus versus Union of India.
1073 of
2016 Lordship.
name?
MD full stop Abdul Quddus versus Union of India. Lordship. In 1073 of 2016.
Date of the order.
Or date of the order, Lordship, 7/5/2018. And relevant para is that Lordship, para 15. Exhibit 1 is a certificate issued by the Gaubura on 2/8/2020. He certified that A. Quddus was son of late A. Kadir and that he was a resident of Botalimari village. Father was a voter of Lahorikhat constituency. A. Quddus was born in Botalimari village but shifted his residence to village Sararpathar village. Though the Gaubura deposed as DW2, he did not bring the official register or record to prove the contents of Exhibit 1. Therefore, the contents of Exhibit 1 cannot be said to have been proved. It is tried that documentary evidence has to be proved on the basis of contemporaneous record and not on the basis of personal knowledge through oral testimony. From the documents as well as from the deposition of the Gaubura, what transpires is that certificate was issued without reference to any official record. However, notwithstanding the same, even if we take the certificate at its face value, what it says that A. Quddus was a resident of Botalimari village but later on shifted to Sararpathar village. And Lordship, one important aspect is that petitioner neither in evidence nor in WSC never stated his place of birth, which is very much essential as per para 26 of the Sarbananda Sonowal 1's case, Lordship. So nowhere he was stated that where is his place of birth, Lordship, and it is most important to establish one citizenship, Lordship. And apart from that, Lordship, one most important aspect in this petition is that there is no continuous stay of the proceeding since 1970 to 1989, Lordship. There is a huge gap, Lordship. After
no continuous stay from
1970 to 1989, there is no document between this period. What happened to his fathers, his parents, what happened to him, Lordship, that was not mentioned neither in WS nor in evidence, Lordship. And in Monodutin on this case, Lordship, regarding continuous stay, what it says, Lordship, just time. 2019 5 GLR 768.
Please come again. 2019
5 GLR 768. Lordship.
Name?
Monoduti Nandi. MONODUTI NANDI and others versus Union of India. Here 6A2 and 6A3 of the citizenship, both are important, Lordship, and both sections are saying about continuous stay, Lordship. And here, Lordship, discuss about section 6A3, para 7 and 8, I am relying, Lordship. The requirement of registering with foreigners registration authority under section 6A3 of the Citizenship Act is subject to the following conditions precedent. And the proceeding came to Assam after 1/1/1966 but before 25/3/1971, and since the date of his entry into Assam been ordinarily resident in Assam and has been detected to be a foreigner. In the instant case, as per order of the tribunal dated 16/6/1993, it is taken note that there is no finding of fact that since the date of their entry into Assam, the petitioners has ordinarily been residing in Assam. The only finding arrived is that the petitioners have entered India between 1/1/1966 and 25/3/1971. As the requirement of conditions precedents of section 6A3 had not been fulfilled in the case of the petitioners as revealed from the order of the tribunal, we are of the view that there is a requirement of law to arrive at a finding of fact that the petitioners have ordinarily been residing in Assam since the date of their entry. So, Lordship, here in this case, Lordship, since 1970 to 1989, there is no such document that proceeds continuously residing or he has ordinarily resided in the territory of Assam. Lordship, there is no document, Lordship, between this period. And those things are also discussed in the opinion, Lordship. So, Lordship, my humble submission is that, Lordship, there is no infirmity in the opinion passed by the learned tribunal, Lordship, so opinion may not be disturbed, Lordship.
What would be the date of birth of the petitioner?
From 1964, if in 25, if he's 61, then it would be 1964, my lord.
1964. It is 61 years for the date of birth to 964. 82 both Europe 74 18 যদি হয় আর 19 যদি হয় 21 যদি হয় 85 বছর হয়েছিল 89 প্রথম আইছে তার নামটা
25 years.
এটা 29 বছর বলে গেছে কিন্তু এইটোৰ পৰা চালে তো 1980
29 years, no?
29 এইটোৰ পৰা চালে তো 1980 ভর্তি করেছে 80 এর উপরে তো আনএক্সপ্লেইন জায়গাটা আছে না You have any documentary evidence to show your link between for this huge gap? Mr. Sharma is harping on this aspect of 1970 to 1989.
Yes.
There appears to be a long gap. How do you explain it? Do you have any other documentary?
The Kirat
Proof.
Patta is also from 1970-71. So this gap has not been explained, but my humble submission would be, my lord, that
You had gone to some school?
no,
No.
he did not go to any school. He's unlettered, my lord. OP did not attend school. His brother stated, my lord. OP did not attend any school. My lord, the Gaubura certificate, my lord, if I can take your lordship to page number, to the deposition of Gaubura. So he is 93, page number 93, my lord. Page number 93, my lord.
আচ্ছা নাকি কপিটো আছে
Thank you.
93 page to 9
93.
Yes, he was, the DW3 was 92 years old. Right. He was 92 years old, my lord. And he says, I am here to depose for OP. I have been working as the Gaubura since 1981. I know OP as he resides at my village. I issued one certificate to OP, Exhibit H in my, is my certificate. I know that the name of the OP's father is Nayamia. After verifying the voter list, I put the content at the name of the OP's father enrolled in the voter list 1965. During investigation, I was not asked by the investigation officer about OP. OP has been casting vote regularly. So, my lord, it is not merely based on personal knowledge. After verifying the document, and my lord, this gap can also be explained from this fact that this DW3 is Gaubura since 1981. And he says, I know them, they are from my village. And my lord, although the ID card was not brought, my lord, but the signature, my lord, which tallies with the certificate, my lord. And also, my lord, there is no specific law which says that a person should come with the ID card. And they could have cross-examined, my lord. But he did not make any inconsistent statement, my lord. And also, my lord, on the link, my lord, about from 89, 1997, my lord, just one house difference, my lord. Serial number, the next serial number is the petitioner. 2005 voter list, the name is written there. The Gaubura deposed DW2 is there. So it is not just 1989 voter list, but also, my lord, the other voter list also there. Very specifically, and the most important part, my lord, which in most of the cases, my lord, that I argue before your lordship, the villages are different, my lord. Here the village is consistent, right from 1965. Borbala. Also, my lord, there are two judgments I would like to read if your lordship permit. My lord, one, I have a copy.
Which one? Sirazul.
My lord, yes, Sirazul, my lord. May I read from the next page, 3, para 3, my lord?
There are three, yes, please.
Yes, my lord. There is no doubt that the great grandfather's name Amtullah appears as Amtullah throughout the document. Equally, there is no doubt about the father's name which appears.
We have read this, Siraj, we have distinguished this in other judgments. Here the discrepancies are very minor one, Kafatullah and Kamatullah.
My lord. So here, my lord, also
And that too in grandfather.
my lord. Also in the Rahim Ali, if your lordship permits, I would like to read one para. This is, my lord, 2024 INSC 511. INSC 511.
2024
INSC, the Supreme Court citation, my lord. 511.
2024 INSC 511.
511, my lord. Para
Name?
41, my lord.
Name?
Rahim Ali. Just one para, my lord. Para 41.
Have you given?
I have not given, my lord. I don't have it. Sadly, my lord.
What is there?
May I read, my lord? The evidence before the tribunal by the appellant to indicate that his parents had been residing in India prior to 1/1/1966, whereas his siblings and he himself, much prior to 25/3/1971, has been disbelieved only on the ground of mismatch of actual English spelling of the names and discrepancy in dates. As far as the discrepancies in the dates and spellings are concerned, we are of the view that the same are minor in nature. Variation in name and name spelling is not a foreign phenomenon in the preparation of the electoral roll. Further, the electoral roll has no acceptance in the eyes of the law insofar as the proof of date of birth is concerned. A casual entry by the enumerators when noting and entering the names and dates of the birth as also the addresses of the person while making preparatory surveys for the purposes of preparing the electoral roll cannot visit the appellant with dire consequences. Moreover, in our country, sometimes a title is prefixed or suffixed to a name such that the same person may be known also by two aliases. The tribunal seems to have been totally oblivious to all this. My respectful submission, my lord, that the anomalies in the age and the names, these are very normal in the voter list, my lord.
Rahim Ali is which paragraph?
My lord, 41. 41. Also, it goes on to explain in the 42 also about literacy rate in Assam.
These have to be read into the facts of each case.
My lord, no. That is very true, your lordship. My just only respectful submission is that about the voter list, that it is not perfect, my lord. There are minor variation in age, in and also, my lord, in this impugned order, my lord, para 21, my lord, I have already read it once. He seems to have agreed that the linkage has been established. Para 21, my lord.
Of the impugned order.
Yes, my lord. Page number 43 of the writ petition.
Please read.
My lord, page 43 of the
Please read.
My lord, coming to the voter list produced by the OP in order to establish the linkage with his projected father, the first voter list of 1918 Exhibit C, which contains the name of 10 voters, namely Nayamia at serial number 604, Haitan Nessa 605, Omar Ali 606, Hanufa Begum 607, Al Mahmood 608, Sahila Khatun 609, Sahar Ali 610, Sukurjan Nexa 611, Samizuddin 612, Basarat Ali 613 purportedly exhibit C shows that the name of the OP appeared in the voter list of 1918 along with his father and mother, whose name appeared in the voter list of 1965 exhibit A and 70 exhibit B, and therefore the link of the OP and his parent has been established, and being the son of Indian parent, he is an Indian by birth. Also, the DW2 Basarat, his name was in the 1989 voter list along with the OP petitioner. They were together. The DW2 Milord.
Where is DW2?
My lord, in the vernacular, page 61, my lord.
No, the evidence.
Page number, my lord, the deposition. Page 89, my lord. DW2, 89. Mm-hmm.
89 is the cross examination.
Yes.
Chief starts from which page? 83.
My lord starts from
81 or what?
Evidence in chief, my lord, page number 82, my lord.
82.
82.
Five brothers, page 83. Three sisters. হেৰি খিনি চাওঁ ভোটাৰ লিষ্ট খিনি চাওঁ 89 361. এইখনত পেজ 61 তিনিজনৰ নাম আহিছে কিন্তু বছৰতৰ নাম আছে আদিদেৱলীৰ টু যে বছৰত নহয় মই ইয়াৰ ভায়েকৰ কথা কৈছো চহৰটো এই বাবু মানৱ নাই নায়া এইটো হ'ল চহৰৰ ঘূণীয়েক বিৰোধী তাৰপিছত সামেৰ বিল্ডিং নয়াৰ
Deep back probably. পটকে ডিজে ডিপ ডেক probably. Itu total 91 years. It is 92.
Opinion so cheap one.
Discrepancies. Asia অলপ আছে না এইটো এইটো থাকে
কিন্তু মানে এইটো আমি দেখিলো কিন্তু ইমানো মেজৰ নহয় যোনটোত
ইনসিডেন্টাল ইনভাইৰনমেন্টটো নাই
Okay. We'll consider.
Yes. And Lordship, only thing is that the basis of Gawura's evidence is footer list of 1965. Nothing apart from that. Lordship, may I go to the cross part, Lordship? Today, cross part page 94, Lordship. Today, I have not brought my identity card to prove that I am the Gawura. I do not maintain my register about my villagers. Nayamia died about 24 to 25 years ago. I do not know the name of OP's mother. I was authorized by the competent authority to use the state emblem. And in the certificate at the top, Lordship, state emblem was embossed and it is not an admissible document. Already law has been settled regarding that, Lordship. And then, Lordship, the distance between my home and OP's home is 1 furlong. I do not know about OP's children. Lordship, OP has 5 brothers, namely Lalmia, Samajuddin. I have forgotten the name of Brace brother. I did not see the grandfather of OP. So, Lordship, only on the basis of this evidence, Lordship, one cannot entitle for citizenship, Lordship, on the basis of this evidence, Lordship. And one other important aspect, Lordship has decided in Iman Ali's case, Lordship, Rahim Ali's case has been decided in Lordship, distinguished Lordship, in WBC 3939 of 2020, Lordship. That much only, Lordship.
No, we are only concerned with whether the discrepancies
Yes.
in this case are major discrepancies or whether such discrepancies can occur in the usual course of business.
Yes, Lordship. A discrepancy of 14 and 15 years of age, Lordship, it may be taken as major discrepancy, Lordship. It cannot be treated as minor
But
discrepancy.
what about the village?
A village may be same by my lord.
House number?
Oh.
You're correct. 14 years this age is not minor.
Yes, Lordship.
But that is in pertaining to the grandfather and grandmother. Correct? And that grandfather, grandma, no, not grandfather. It was of, yes, Malik and
Malik is the grandfather, Lord.
grandfather. Niyamiya is his father.
Father.
Okay, we'll consider,
Yes,
we'll.
Lord. Grateful, my lord.
That's it. AW Aman, huh? Control code.
এইটো মোৰ নহয় ন এইটো আমাৰ এইটো নেকি আপোনাৰ ৰাইট তোমাক দিলো নেকি দিলে grateful, my lord.
Material আৰু পালে কৈ দিম।
সেইটো চেনিটাইজ দি দিলে হৈ যাব।
I please, your lordship.
Yes,
Lordship,
please.
we have filed an additional affidavit that day before yesterday, your lordship, and which has not yet come to the record, your lordship.
Additional affidavit regarding what?
In reply to the affidavit in opposition, lordship.
You had filed rejoinder affidavit.
Rejoinder affidavit, your lordship.
What is the matter about?
The lordship, this is the matter that pertains to the custodial death of a student, your lordship.
Student?
Student, lordship. No.
Where, which school?
Lordship, it is Nagaon district, your lordship, under Dhing police station.
Residential school or what? Normal school?
Lordship,
Hostel?
normal, lordship,
Custodial
allegation
death means what?
he was arrested on a gang rape offense, your lordship. Later, the accused was taken to recreation of the scene, lordship, at about 3 a.m. in the morning.
3 a.m.
3 a.m., your lordship. And
What was
allegedly
his
the
age? What is the age of the victim? Victim means your client, the deceased who has passed
deceased,
away?
your lordship, it is he was
He was a student, the deceased was a student.
yes, your lordship.
Of which class?
24 years old, your lordship.
24-year, college student.
Yes, your lordship.
He was an accused in a
Gang rape.
gang rape case. So
Yes.
he was taken for recreating the sin.
Sin.
So what had happened thereafter?
Thereafter, according to the police, your lordship, he trying to flee from the police custody and fell into a pond, your lordship. Thereafter, he drowned there, as per the police report. Lordship, it is very much discrepancies is there, the times and time of death, and that are the SDRF report says also different.
What is
things,
the PM?
Lordship?
What about the PM?
The Lordship, postmortem report says antemortem drowning, Lordship.
Drowning.
Drowning, Lordship.
Was any injuries found on the body of the deceased?
Lordship, postmortem report at there
number 95.
95 in the
Injuries found?
within opposition, your Lordship.
Yes, lordship. No, lordship.
No physical injuries.
96.
Reason is what? Drowning.
Drowning, lordship.
Lordship, in the inquest report, it is shows that some bleeding, nose bleeding was there.
No, if one drowns, there can be bleeding through the nose. But we are more on the aspect of injuries on the body.
Lordship, there are very much discrepancies in the time related time of death, your lord. The postmortem report also does not show any time of death. And the SDRF team also says that they were called at 4:23, your lordship, and
No, Mr.
There-
Counsel, what is your name?
MH Ali, your
Mr.
lordship.
Ali, our concern is that if you are trying to invoke the public law remedy for seeking compensation, we have to come to a conclusion that the death has been caused deliberately or by gross negligence. An accidental death or a natural death will not come into the ambit of a public law. You can go to the private law, and get an investigation done, everything, compensation. But here, to invoke that jurisdiction, you have to make out a prima facie case.
Lordship, as the matter is conducting by my senior Mr. Z. Khalid, and we have filed the additional affidavit in reply to the affidavit in opposition, let us some.
Okay, we'll have some other reason.
Lordship.
You have been served with a rejoinder copy.
No, no, no.
Not
I
been
have
served.
Not received of it.
Serve him.
Okay,
You have not served.
I have served a copy with a notice.
No, whoever is,
Extra copy
it
will
may not be to, but you have to serve in the office. Have you done that?
Yes, I have served a notice here, Lordship, and with a.
DNR will apprise in court.
Okay,
Lordship.
okay, we'll have it after when?
After 2 weeks, Lordship.
2 weeks. Lordship.
A date may be fixed, my Lordship.
No.
On
Your Ali,
MH Ali, your Lordship.
Sri M.H. Ali, learned counsel for the petitioner, has submitted that rejoinder affidavit has been filed
On 8th,
yesterday,
yes, that
Yesterday.
day before yesterday.
on 9th,
8, your Lordship.
8th,
8.
8/11/2025, which however has not been tagged with the records. Full stop. Let the affidavit be tagged with the records and the matter be taken up for consideration after 2 weeks.
A date may be fixed, your Lordship.
On request list on
26, your Lordship.
twenty-sixth, okay.
Obliged, Lordship.
May I please, your Lordship?
Hmm.
Lordship, the pleadings have been exchanged in this matter, my lords, and we are ready to argue this matter as of today, my lords. They have filed a affidavit in opposition, and we have filed a rejoinder affidavit, my lords.
You are for the sole respondent.
Yes, ma'am.
File your affidavit.
Yes, ma'am.
What is the matter?
The matter is about contempt, my lords. There is an order passed before the family court, my lords, with regards to child custody of the child, wherein a interim visitation order was passed by the learned family court, Kamrup Metro, my lords, which, my lords, we have filed a contempt that is in deliberate violation because they stopped producing the child, my lords, at the designated visitation place.
Yes, what do you say?
My lords, there are a lot of acquisition and counter acquisition, my lords.
Yes, just a minute, yes. We are concerned with the directions, that
Your
visitation right.
Lordship, Your Lordship, actually, I carry out the order. Child is aged about 6 years. The child is with me, my lord, from
You are the mother.
his birth. I am the mother. Now what happened, my lord, the court below directed me to produce the child twice in a month on Saturday. So, my lord, I produced the child in earlier occasion, but every time, my lord, child is not willing to meet his father. Maybe some reason. But on the last occasion, my lord, from which date I stopped to produce the child, I brought the child to the police station, police outpost. So thereafter, what happened, my lord? The petitioner before your lordship, that is the father of the child,
Yes.
went there, my lord, with some persons, other persons. So after that, when under scene is like this, the child was frightened. Anyhow, my lord, I brought the child to the police outpost. But the child is adamant not to go to his father. Father tried to meet him, but he is not willing to go there. Then when the child was coming back, then the father blocked the road of the child. Then child started to cry. Facing that situation, my lord, I was helpless. Then I brought the child somehow to my car. And what happened, my lord? When my car was proceeding with the child, these persons, those persons who were present there, they blocked the gate of the car. They did not allow to car come out with the child. Then there was another problem. Anyhow, my lord,
What do you do, Mr. Burman?
after
I'm a
some
private consultant, my lord, working at Department of Finance. My lord, she is a superintendent of tax posted at Jorhat. My lord has taken the matter. My lord, the allegation that has been given by my learned colleague, my lords.
She's a senior colleague.
Senior colleague, I'm so sorry, my lords. So apologies, my lords. So basically what has happened is this, my lords, that there have been allegations, my lords, there have been hail of allegations given by the petitioner, my lord.
Have you set for mediation?
My lords, we have actually what happened, the family court had rightly, my lords, sent this case for mediation. She does not appear before the mediation. My lords, the reason being that, my lord, may I kindly come to page number 11. my lord.
Sikh, why don't you go sit for mediation?
my lord.
Sit for mediation in the
My lord,
interest of
what
the
happened, my
child.
lord?
My lord, may I take up the orders.
My learned friend, my lord, wrongly submitted before the court. I did not appear from the mediation. That is not the thing. Mediation was done. Sometime he was absent. My lord,
No, Mr. Sikh, Mr. Burman, see,
my lord,
referring for mediation doesn't mean that it will end up with an amicable solution.
my lord.
It might not lead to any solution, but we can make an endeavor, a sincere effort to come to a solution. Solution means
Yes.
not that you start to live together. We can still be living separately, but they will be living separately peacefully.
My lord.
And that would be in the interest of the
That is
child.
that.
So in that line,
My lord.
can you think?
Hmm.
Because see, this matter is going to, ultimately, it's going to end up with nothing.
My lord.
Either we hold you guilty
My lord.
or you don't hold you guilty.
My lord. So, my lord,
That is, either ways, the child is not going to be benefited.
my lord, child is to be benefited.
Is not going to be
My
benefited.
lord, what happened?
Whether we send you to
My
jail or
learned
not send you to
friend-
jail.
No, my lord. My lord, my learned friend filed guardianship case.
Yes.
And I filed divorce suit. My learned friend filed restitution of conjugal rights. 3 petitions, my lord, pending before the family court. What happened, my lord? After filing this contempt petition, they filed a CRPIO
For?
for staying the proceeding of guardianship.
Actually, what has happened, my lords?
Let me submit
I'm so
one
sorry.
after another.
Now, guardianship, who has filed?
Guardianship filed by his client, my learned
And why CRPO against stay of?
that he filed, after filing this contempt petition, my lord, he filed a CRPO, filing that he stayed the proceeding of guardianship. Guardianship, he claimed, the guardianship proceeding is stayed by him. Now what happened, my lord? That is not the end. Immediately, he filed another WPC. WPC saying that CWC interfering with this child. So in the WPC, my lord, notice was issued, there is an stay. CRPO and stay. Now what happened, my lord? When I could not, child was or not willing, then my lord, I filed a petition. Petition before the family court. See, order is there, but under certain circumstances, I could not force the child
My
to
lord,
meet
no
his
notice
father.
of that application has
Oh,
been given to me, my lord.
why my
No
learned
order, my
friend
lord.
start?
No order, my lord.
Start.
That is a misleading statement
Let
by
him
my learned
complete,
senior
my
colleague,
lord.
my lord.
Thereafter I will
My
say.
lord, there are everything in affidavit in my lord's affidavit in their affidavit, my lord, if I may say, my lords.
So basically what has happened, my lords, the visitation order was
See,
given
your
in-
fight is affecting the child.
Yes, my lords, exactly. So what has happened, my lords, in 7 September.
Don't let the child suffer, you fight.
No, my lords, the child is suffering because of her arrogancy, my lords, in my humble submission. My lords, 7 September, see, my learned senior colleague-
6-year-old.
So basically,
Son
he was
or-
separated from
Son
me.
or daughter?
Son, my lords. He was
Son.
separated from me.
Studying where?
Studying in Jorhat, my lords.
You are at Jorhat
Yes,
My lord, I am in Jorhat, my lord, superintendent of taxes.
and you are here in Guwahati.
Guwahati, my lords. So basically,
And the visiting rights were where? Was where?
in Jorhat, near, just 150 meters away from her residence, my lords, in the police station, my lords. So basically, what has happened, my lords, but the child was separated from me when he was just 6 months old, my lords. I could not see the son any times until this visitation order was given to me. So, my lords, in my no stretch of imagination, my lord, how a child can hate a person whom he, my lord, does not recognize as a father, my lords. Then I put this question to myself. Then in 7/9/2020, so basically what has happened, first of all, my lord, she filed a DV case against me. In the DV proceedings, my lord, we filed a case for visitation of the child. The moment we filed a visitation for the child, my lord, she withdraws the case. Because she wants to keep the child away from me. My lord, therefore, we filed a guardianship and ward case immediately. Thereafter, what happens, my lords? Then she filed a transfer petition, my lords. That transferred a
No, we don't want to go to the history of litigation.
Yes, lords, exactly. Now,
It will be
these
unending. It will
allegations,
be unending.
allegations.
Unending. Tomorrow there will be some more.
Yes, my lords.
We want a solution to this.
Solution to my simple, my lords. She may have all rights to not come to me, or my lords, with regard to whatever, my lords. But son, with regards to son, my lords, my humble submission is this: I'm the natural guardian of the.
Mr. Sheikh, if you are having a difficulty in complying with the orders, you file an application, get the order modified.
My lord, I filed the petition. That is why, my lord, I start and
If
my
I may come,
learned
my
friend,
lords.
when I start,
then what
my
has happened?
learned friend interfered.
What has happened then
My lord,
in that
that petition is pending before the family court. I have annexed with my affidavit.
When is the next date?
I stay before the family court. That's
Now,
it
when
may-
is the next date?
my lord.
When is the
Next date in the case, that guardianship, my lord.
You know, your application for modification of the order
Yes,
of
my-
visitation.
my lord.
When is the next date fixed in that application?
My lord, when petition was pending, immediately that record has been stopped, my lord. Now the family court is not dealing with the matter. Guardianship case, there the petition has been filed. They filed the CRP IO. So proceeding is state. So family court could not fix the date of this case.
My lords, why CRP Iowa State, my lords? I may just come to my petition in reply. my lords.
Problem
No,
is,
Mr. Sheikh,
my
see,
lord,
unless that order is modified,
my lord,
you have to comply.
my lord, that point is
See,
there.
if the child does
that-
not want to meet the father,
That point is there, my lord, but your lordship, when I filed a petition, the court below will decide.
since when the visitation thing has not been carried out, Mr.
Since, my lords, 27 July 2025. My lords, my learned
27
senior colleague,
July,
27
25
July 2025.
last date.
Last date.
She had come.
She had come on 13 July 2025. From 27 July 2025, she has stopped coming. My lord, with regard to visitation order, my lord, if I may say, so basically what has happened is this. My lords, during the family court proceeding, we objected that the child may not be allowed to produce in Gormur police outstation because we pleaded before the family court, the learned judge, that since she is a bureaucrat there and she is a superior authority, because if she goes for raid, it is the officer in charge of that police station who accompanies her, so it's a superior authority. So there might be some influence that may be there. And thereafter that happens, so my lord, on the first day of visitation itself, there's an email, my lord's communication on the first visitation itself. We wrote to the Superintendent of Police Jorhat saying that there is some kind of interference. Now, then we file a petition before the family court that there might be some modification made to the order. Well, the family court order, in my affidavit in reply, my lord, I have given the order sheets. So in that, what he does is this, my lord, that he does not dispose of this petition. Then, my lord, they say that they have filed an application somewhere in 23 July 2025. My lord, that they stay of the proceedings of the visitation order. So, my lord, what happened? Thereafter, there was a date, 6 September 2025. My lord, this application which he put for stay, neither that notice was given to us, neither that was argued on the next date. So, my lords, they have not done anything. First of all, my lord, neither she comes to the visitation, neither she does anything. So, for enlargement of the visitation petition, my
Okay,
lords, we file an CRP.
Mr. Sheikh, unless that order is modified or set aside by any higher court, you have to comply with. If
My
the
lord,
child,
my lord,
listen to us.
My
If the
lord.
child doesn't want to meet the father, it's a different aspect.
my lord,
But your duty, which is given to you, which is direction given to you, you have to abide by the direction, to comply the direction, with the direction. Bring the child. If the child does not want to meet, matter ends there, come back. But unless it is modified or set aside,
your lordship will consider, your lordship would be pleased to take my affidavit in opposition.
He has filed an
Yes, my
application
lord,
which has not
affidavit,
got the notice.
affidavit in
And it gives a
opposition.
lot of annexure, but annexure.
Oh, my
is
lord,
not-
what happened? When I start to submit, my lord, he started to submit. That is not the way.
have you seen?
Let me complete, let
yes.
me complete,
Yes.
be patient. Now, your lordship, affidavit in opposition, I have filed, my lord.
First, let us see the order which has been violated
My lord, that is in page number 11, my lord.
of your petition.
Yes, my lord. My lords, has it, my lords? May I read it, my lords?
Just a minute.
Yes, my lords.
7924, my lord.
Yes.
So your
Yes,
lordship would be pleased to turn to page 28 of my affidavit in opposition.
Just a minute, Mr. Abhishek. 7924. You have filed your affidavit.
My lords, yes, my lords.
No, you see the.
Yes, my lord.
Where, which page?
My lord, page, your lordship, page 28. Affidavit starts from page 20, my lord. Page 20, then my lord, my petition at page 28.
Under 151
My lord, 151. Your lordship,
for modification.
the petition was filed on 23/7/2025.
Yes.
So, my lord, in this petition, I have elaborated the situation under which I could not produce the child, my lord. Your lordship would be pleased to see para 4. In compliance of order dated 7/9/24, the present petitioner had been producing the child at the outpost. Thereafter, during aforesaid visitation, the child was always scared. Photocopy of petition. Now, what happened, my lord? Occasion and facing by the situation, the present petitioner filed petition number 1911 of 2024 on 25/11/2024. This court narrating entire development in.
No, see,
connection of
this
said
proceeding is
visitation.
not stayed.
My lord.
The guardianship proceeding is not stayed.
My lord, guardianship proceeding is stayed by this.
Which case?
My lord, guardianship proceeding, CRPIO, my lord.
That's my lord.
Oh, just a minute. Will I come to you, Mr. Burman? Have a.
Guardianship proceeding was statement.
That is in, my lord, page number 22. Page number 44 of his affidavit in opposition, my lords.
My lord, guardianship.
But this order is not been stayed. Page
Mr.
number
Burman,
44.
have a seat. He'll answer.
Yes, 44.
My lord, if my learned friend want to say every case, my case, his case, let him continue, my lord.
No, I'm assisting, my lord.
My lord.
That page number 44.
No, we'll have your assistance when required. Now have you sit. Okay, that is stayed by 22/9/2025. We do one thing. We'll have this case.
CRPIO. My lord, this is CRPIO may be called for along with this case.
Single bench ল'ব ল'ব পাৰিম নোৱাৰা কথা নাই এইটো মানা কিন্তু এটা তেওঁলোকৰ ওপৰত যোৱা এটা স্কোপ এটা কমি যাব নে চিআৰপি এজেঞ্চি এনেও আপোনাৰ সুপ্ৰিম কোৰ্টে যাব লাগিব hardly make any difference. When division bench is over enough. We can have the CRPIO before
Along with
together
this,
with this.
Yes, my lord.
Okay,
Yes, my
we
lord.
can modify that kind of an order.
Hmm.
We have also explored the option,
Hmm.
because if you, any party is aggrieved by any CRPIO, you cannot go for a division bench. So you'll not be, there will be no prejudice cost to you in case.
Hmm.
Yeah, then either party, if aggrieved, has to go to the Supreme Court. Even in the CRPIO, no division bench is there, so we can take it up, no problem as such, okay? Third, Sri M. Burman, Learned Counsel for the petitioner, as well as Sri M. A. Sheikh, Learned Counsel for the respondent. Full stop. The instant contempt petition is with regard to an order dated 7/9/2024, passed by the learned Principal Judge, Family Court number 1, Kamrup, in Miss within bracket G, case number 153 of 2022, giving visitation rights to the present petitioner. Full stop. It, however, transpires that the said proceeding is the subject matter of CRP IO 411 of 2025, in which an order dated 22/9/2025 has been passed, in which the further proceedings have been stayed. The state proceeding is relevant in the sense that the learned counsel for the respondent has informed that on 23/7/2025, a petition has been filed for modification of the order dated 7/9/2024, which, however, has not been able to be taken because of the interim order passed
No, my lord.
by this court.
Yes,
That is his submission.
that is the
Yes, my
thing.
lord. Then, my
That
lord.
is his submission. Don't
Yes.
say no to all
Yes,
matters.
Yes, my lord. Yes, my
This is not our finding.
Yeah.
In view of the above, we direct the registry to list the present case along with CRPIO number so and so, huh? CRPIO 4112025.
My lord, just one last request, my lord. My lord, may record my one submission that this petition order dated 23/7/2025 has neither been served to us, neither notice has been served to us, neither, my lords, it has been ever recorded in any order sheets of the, my lords, learned court below. That submission, my lords, may only be recorded.
That will go by the record where.
That everything will be clear
One
while
thing
the
like
record.
that, you can accept notice in that.
If,
Did you take steps in
my
that?
lord, everything will be clear, my lord, while the
Sri
record will
Burman,
come.
The learned counsel has, however, clarified that till date, his client has not received any notice of the aforesaid, which case?
For the 23/7, my lords, petition that they talk about, my lords,
My lord.
of modification of the.
Yes.
Yes, so it has clarified that copy of the petition said to have been filed on 23/7/2025 has not been served upon his client till date.
And my lords, last addition, that neither it has been ever recorded in any order sheets of the learned court below.
No, no.
That is under
my lord,
stay. Where
my
it-
lord,
No, my lords, it was not in stay, my lords, 23/7. After that, my lords, there was an order.
Only
We'll see,
thing,
we'll see, we'll see.
Yes.
only
see
thing is this, my lord, when record will come, no submission is necessary.
This is
we'll-
necessary
we'll-
because there are a lot of misleading statements, my lords, given before the court
Oh,
today.
oh, don't use this word,
We'll see that.
misleading.
But one part may come, Mr. Sheikh.
My lord,
One part may come for you to explain.
my lord,
This interim order of stay has been passed sometime in the year, sometime in September.
yes, my lord.
And your petition for modification was filed on 23/7.
My lord, that is there, that, before that, my lord, before that, I was bringing the child to meet his father.
No, on 23/7/2025,
Yes, my lord.
when you had presented the petition for modification, what had happened?
My-
High Court stay order
That-
came to us.
let me clarify. my lord. Case was for conciliation. I filed the petition. Then the
Okay, that
judge,
might have to call
then
for the order sheet.
then the honorable
Yes,
judge, my lord, honorable judge passed an order, the place with record. In the meantime, my lord, the conciliation is over. Let me clear, my lord. Conciliation is over. Case was taken by family court. When
Okay,
family court taken the case, my lord, in the meantime, this,
We'll like to
yeah.
see that the, oversee
my
that
lord.
the
You-
orders are complied with, otherwise consequences.
my lord,
My lord, and I'm great.
orders will be complied with, my lord, but
Otherwise
your
consequences.
lordship,
Your option.
your lordship would be pleased to consider about the site. My lord, I am mother, my lord, I cannot force the child to me. If necessary, my lord, he can talk some way, my lord. Your lordship can talk with him also, that child. My lord, your lordship, my
Okay, we'll-
position is this, my lord.
We'll
I cannot force the child to
We'll
meet
look
the
into it,
father.
we'll look into it.
My lord, says
After all, my lord, prime is the interest of the child.
When we have this matter,
My lord, one last thing, my lord, as has fallen from my lords, that the order or my lord, record of the learned court below may be called for, my lords. Since CRP IO will be taken, my lords.
CRPI is not before us. Where do we call for the records?
Okay, my lords. It seems my lords has.
Let it be tagged, then we can pass an order in that case.
Yes, my lords. My lords,
We'll
any
give a
date, my
date
lord.
list on. Today is what? We'll have it on 1st of December. Monday. Okay?
First of this,
Yes.
oblige, your lordship.
Oblige. Oblige.
Me, please, your lordship. Lordship, here I am appearing on behalf of Mr. S.P. Chaudhary, lordship. And we have filed this IA under section 5 of the Limitation Act for condoning delay of 3 days, lordship, in preferring the instant appeal, lordship. And the grounds for delay has been explained in para 2, 3, 4, 5, 6,
We
7.
have to issue notice.
Lordship, only 3 days delay is there, so it may be condoned, lordship.
No,
Otherwise,
it's
it will
not a
be-
question of if the other party exceeds, even 1 day's delay, we have to issue notice. Without notice, we cannot, unless the other party, who's the other party? Is there any private respondent? Who is the private respondent?
Lordship, it's a partnership firm and deputy commissioner.
Or one defense, no, there's no private respondent. Who is the private respondent?
Opposite party number 1 is the private respondent and others are government.
No, who's the applicant?
Applicant is the Union of India, Lordship.
Oh, you're not Bhauram
No,
Dhodra. No,
no,
then you have to issue notice, madam. That is not the law. You have to issue notice. Okay, heard your BDB,
Yes, Lordship, on behalf of Mr. S.P. Chaudhary.
heard Ms. BDB Learned Counsel appearing on instruction of Sri S.P. Chaudhary, Learned CGC,
Yes, Lordship.
who has filed this application under section 5 of the Limitation Act for condonation of delay of 3 days in preferring the present appeal. Why is it come before us? Writ petition, writ appeal? Huh? এটা তো হেরিকে বলেছিল, ডিভিয়নজা বলেছিল। Division matter. Let notice be issued. Returnable by 4 weeks. Oh. Let steps be taken for service of notice upon the respondable one by speed post with AD. Steps within 2 working days. Three, your name?
HK Hazarika.
Your state council.
Yes, Lord.
HK Hazarika and state council accepts notice on behalf of respondables 2 and 3.
PN follows.
2 and 3.
Oh,
2 and
2 and 3. Extra copies be served upon him by tomorrow.
Obliged.
In the original petition. Original petition.
May I please? That's it. This IA is for condonation of delay also. There is 65 days delay also in filing the writ appeal. And the reason also I have explained paragraph 6 lot.
Other side,
And that's the state respondent, BTC as well as the department. There, if
we should notice. Yes.
No, I'm
we are
appearing
from
for respondent 1, my lord.
Corporation,
No, my lord, elementary education,
elementary education.
respondent 1.
Okay. Would like to have some instructions?
Well,
You may not file objection, take the instruction,
Right.
we'll condone the delay, okay? Heard. 3A Deca. Learn, this item number?
item 41.
counsel for the petitioner, for the applicant, who by means of this application filed under section 5 of the Limitation Act has prayed for condonation of delay of 65 days in preferring the connected appeal. Para, let notice be issued, returnable by 4 weeks. Sri S.K. Talukdar, you are sitting counsel,
My lord,
elementary education for
respondent one, my lord.
one, finance. Finance. Who's there in the court? H. Ali for two. Madam Deka,
Happened for BTC on
BTC. R. Deka,
Ardas.
Ardas.
3 বা 10 বুলি কয়।
3, 4, 5, 6.
3, 4, 5, 6.
All the respondents.
Or 3 you are there. Ardhar.
4 to 10.
And 4, 5, 6, 7, 8, 9, 10 by Miss R. Das, appearing on instruction of Miss B. Bhuya. Sending counsel BTC. Extra copies.
Just since parties have represented, they'll maybe condone.
They have to have the instructions. They may not file any objection, but they don't have the instructions. Suppose tomorrow they have the instructions to oppose.
Not.
First day we cannot force them.
Yes.
Not certain.
And the amount taken is double the amount of limitation. 60 plus this.